2. Page number 2, item number 3 to 6. Page 3, item 7. Page 4, item 8 and 9. Page 5, item 10 to 13.
Item number 12. Item number on the BC matter. Item number 12. Yesterday, you received directed the retopic number W25723 to be listed tomorrow, my lord. But today it has wrongly come, so may be taken up tomorrow along with WPC WA 225723. That Kondagara matter you will receive
tomorrow with the request of Mr. Nigama Mistral and Consulting with the respondent along with the viewer numbers is in search. What is the number?
W2257.
All right.
My lord.
That's the same page item.
Have you informed the council for the appellant?
Appellant the state, my lord.
The council has taken the brief.
Yes. I'll do that.
All right.
Sir.
Same page item number 11 below. On behalf of Mr. Tripathi, my lord, appearing to OC number 6, kindly allow 1 time to find the count. I've taken a consent of my non-senior.
All right. Let the matter be listed on 11th of October 2023. What is your good name, sir?
R. Achari on behalf of Mr. Tripathi.
Mr. R. Acharya.
Causing a lot of hardship.
Just a minute. Do you have any objection, sir?
For the petition.
Do you have any objection? He says you have no objection.
Yeah. No, I have no objection there to file a counter.
All right, there we are fixing
Let
the
an
matter.
hourly date be fixed. That's all.
11th of October.
11 October. 11 October.
If it could be little earlier, my lord, because the petitioner's handicap is there, the customer's
We are
handicap
marking
is
that
there.
this is the last chance. All right. 11th of October. Meanwhile, the respondent shall invariably file. The opposite parties shall invariably file their counter affidavit, as this court will not provide further extension of time for the same purpose. Yes, Mr. A. Bakchi, let me translate this for the people.
Page 14, item 14. Page 15, item 15. Page mentioning over.
Pardon to mention, my lord, on 2019 matter, your lordship has heard the matter at length and adjourned today. It has not been listed. Any date, my lord, as per the convenience.
Whether it has been still with this court.
Yes, my lord. Your lordship has, because it was special assigned to my lord in the earlier occasion. That's why my lord has been heard the matter regarding that process servers.
There has been certain changes in the assignments. Have you checked out whether this still falls in this assignment of this court?
It is, no, I have not checked because it's a matter relating to that judicial servants.
In number of all right.
Take the record number 3, sorry.
Pardon to make a mention, my lord. This is the public interest litigation petition. My lord, BMC is going to make construction of a drain over the below 10-foot road. If drain will construct, local people will face lot of problem for their communications. So matter may be taken up for tomorrow or day after tomorrow.
You don't want a drain to be constructed.
Below 10,
Magnet. Huh?
below 10-foot road. Over a below 10-foot road.
So what is the problem of the people?
When there is local people will face communication problem, even if guideline is violated
It is
also.
below the road, na? So how will they face difficulty?
There is a gas line along with the water storage or water line also below 10. That is violation of a guideline, my lord. Below 10-feet road, narrow road.
And that is the reason why they are going underground of the road. They don't have other space also to construct.
There is another place also, there is availability of another place, local people.
Unnecessarily, you are just obstructing.
No, I am not paying for to stop the construction, but there is another, they have acquired some lands, another passage of land they have to acquire, a drain will connect to the main drain.
Already you give the case number to Mr. Mohanty is there?
Yes.
You just take the case number, take the instruction. What is actually, I think, there is nothing to be interfered by the court. Listing the matter tomorrow, you just take the information just.
BMC.
Yes, just.
They keep itself. Yes,
Office user 848 2023. WPCPL 28848
Is tomorrow.
So they have already acquired some passage of the land, another land has to acquire. It is a PIL under the Railway Act. We are using the railway level crossing for last 50 years. So the Railway Authority has now taken decision by issuing a publication in the local newspaper to close it down by 15/9/2023. By Friday, they will close it down. So many thousands of people are there going and coming over the. So I think because
There is any alternative.
alternative because it is the only process for the patient students.
Pardon, my lord, may I please, my lord. This is a Pani Panchayat election matter. Actually, election is on 14th of this month. And without making us a party, by following the rate application number 1221 of 2023. In that rate application, the Mr. Ratho, Justice Ratho sir directed to take up the matter within 3 weeks. They did not make us a party and file the rate. And the election is on 14th. That's why I request you to kindly list it on tomorrow, my lord.
What, you file a writ appeal?
Yes, yes, madam. Election matters.
Any interim order is there?
Yes, interim order is there to take the matter within 3 weeks.
No, to take the matter is not interim order.
No, interim order is not there.
What are you challenging then?
I am challenging that they did not make us a
Go
party.
to that court and file an application for impleadment. Where are you coming in a writ appeal when there is no effective order has been passed? No, he said no order. He says it might be taken at 3 weeks. Any order passed restoring the election or anything? I understand. No.
In the writ petition, has any interim order been passed?
No, my lord.
Only thing your grievance is you are not a party.
Go there, not a party, and they did not consider my matter that this should be taken, matter should be
Go
taken.
there, file an impleadment application before that, in that same petition. We are filing the
My lord,
writ.
the election is on 14th, my lord.
So
That's
today itself you file an application. Nobody's there. And there is no interim order storing the election. Where you are anxious. Go there.
Elections are on 14th. Has it been stopped?
no.
Then what is your problem?
You go file an impleadment petition in the before the writ petition proceeding. Yes.
Your Lordship, one writ appeal, your Lordship was pleased to direct to be listed on 2 p.m. on several occasions, but due to paucity of time, it could not be listed. Now the respondent is suffering a stay order. The unauthorized construction was directed to be demolished.
Listing the next Monday.
My lord, obliged.
But I may be permitted to mention one matter, my lord. These are writ appeals of 2022. Lord, as per your lordship's last direction, it was to be listed on 4 September. The vehicles are standing for last 8 months, helping neither of the parties, my lord. And this honorable court has already decided this issue in writ appeal 97 of 2023, my lord. Lord, where may be listed this covered matter, my lord.
3 matters, I think. 3 matters.
3 matters, my lord. Lord, tomorrow, day after, what?
Here is, here is the way of 2004. And contempt was filed on transport 2013 disposal by the Honorable Court. There was an order if not complied, the same with contempt. Till 2013 till 2023, the matter not taken up, the petition is suffering a lot. He has retired in the meantime.
Division bench will do this.
With several filed with the registry as well as the sum of the single bill.
Second matter, go to
I filed several, but not yet been listed. That's why I'm constrained. I approve this Honorable Court. Before registry, I mentioned not less than
Monday.
I may pardon my lord. This is the regular appeal, writ appeal, fresh admission, my lord. I pay next week, my lord.
Sir, I am a retired person. In departmental examination was conducted by CSU, whereas they have held me biting some grudge with me, my higher also. This is my request for a evaluation for answer paper.
Have you filed the writ petition?
Huh?
Why are you coming before a division bench?
Yes, sir.
List ହେଇଥିଲା?
लिस्ट गला थर लिस्ट ହେଇଗଲାନି 8 ତାରିଖରେ ଆଉ ତା ପୂର୍ବରୁ 22 ରେ ପଡିଲାନି
ଏଇ କୋର୍ଟ ରେ ଥିଲା?
ଆଜ୍ଞା
Division has been dismissed.
My lord, I filed IA according honorable court directs. Honorable doubly authorized to the issue of the coming tomorrow.
ଆଇଏ କଣ ପାଇଁ ଫାଇଲ କରିଛନ୍ତି?
IA madam file the late filings and certified.
Just take up the
ଛବି ଲୋକ ମାନେ ଆସନ
I think ଡକା ହେଇନି.
I mean, pardon. I may be pardon to mention
Yes.
item 6 of the list, my lord. Honorable Mr. Sahu is not well, is suffering from fever. I pray can taken up next week. Item 6 of the list.
All right, you just wait a few minutes, then we'll take up the matter. Yes.
Item number 9 to be called out. Item 9 please.
Lordship have put me a query, raised a query whether I have intimated or not. But not necessary. Of course, I have not intimated. Lordship may kindly see their own affidavit, page 3. Yesterday, which was filed.
This is one.
Regulation 17A. Sub-regulation 4 to 17A. What it says? It says office bearers or key functionaries or members mentioned in the application for grant of registration or prior permission. Here that has been already granted of registration or renewal of the application. Now the renewal of the application has been made on 22/4/21 and the living person was not dead by so-called field inquiry report. Lordship see the and prior to this amendment matters, the central government had issued a notification that only where 50% of the key members have been replaced, then only I am handing over to page 3. I'm sorry. But the stories are being built one after the other. The language says or prior permission or renewal of registration, and the earlier notification matters will see at page 3 I have. 17A4, key members of the association, if at any time of such change cause replacement of 50% or more than the original key members as reported in the application. When it doesn't strike the common sense that at the before grant of this renewal of the registration, I have to intimate. And that time all this member was member was very much alive. Who was made dead?
Our question was subsequently after she died, have you informed?
No, I am not informed.
That's all. That's
I
all.
have not.
That is all. That is all.
Yes. Now, my lords, you will see. Because why I am not, it is not required so far as 17A4 is concerned, my lords. Now, my lords, you will see how this.
No, this we had asked just to have the
Yes,
facts.
yes. Correct, my lords. I am not obliged. My lords, kindly turn to page 5. Again, the same repetition. It is I am reading, my lords. Para 6 of their affidavit yesterday file. It is again reiterated that the petitioner had diverted the foreign contribution for undesirable purposes and involved in the activities other than those permitted in the FCR regulation certificate, and also contrary to the aims and objects mentioned by the association in its memorandum of association. Members, I am really shocked to the audacity of the officer who has filed this affidavit. Instead of tendering any apology, my lords, he has started blaming the petitioner, my lords. Then again, not a single line that I am apologizing.
Yes.
Then, my lords, page 7. It is submitted that the petitioner's association is registered under the FCRA, Foreign Contribution Regulation Act, for social purposes, and the petitioner's association applied for renewal of registration for social and educational purpose. However, from the facts mentioned above and further in para 6(8) of the additional affidavit, is amply clear that the petitioner has diverted the foreign contribution for religious agenda and involved in the activities. But what is this, my lords? You first say that I am not intimated. It was cancelled. Then you say again that this is a siphoning of the funds for other purposes, which your lordship have perused the field report.
Scanning. Scanning.
It's absolutely clear that the petitioner has diverted the foreign contributions for religious agenda and involved in the activities contrary to the aforementioned aims and objects. Well, if I give a home to the autistic children, to the children who are cerebral palsy and also mentally retarded, have I committed any sin, my lords?
Yes. That's all.
My lords, another thing, lordship knows it very well, that you cannot add something, develop your case through affidavit. Once you are rejected, you have filed the counter affidavit, not a whisper is there. Not a whisper that because of the non-intimation, the same has been rejected. That is not there at all. Now you are developing a new story. Well, four times this is happening, my lords. And this matter is lingering since 1 year, my lords. There, the home is without any funds, which they are getting, my lords. And on false and fabricated things. And look at the audacity of the officer, my lords. He takes the court to be a playground, makes him dead, makes the sister dead. In April 2020, no date has been mentioned. Lords, you will see para 5 of the earlier affidavit which they have filed earlier.
Yes.
This affidavit also they have admitted that
Yes.
it's in April.
Yes, April, no date. Nothing to support it. And now they say that we inquired from the field officer after getting my affidavit. And so casually they have taken. They have taken the court to be granted. Whatever they will say, that officer will say that will be accepted. Matters recently, on 6th of September, matters, Justice Gawai and Justice,
Mr.
yes, just a minute. Judgment of proceedings. They have said that because the officers are not paying from the own pocket, such frivolous litigations are being, and I am giving the copy matters. And they have imposed costs of 5 lakhs rupees each to be paid to the Supreme Court Bar Association and 2.5
the state filed the frivolous.
Yes.
You filed the litigation here.
No, here I am fine. I am not saying that. But yesterday I have shown the affidavit of just I am bringing. I just am bringing to the notice. Yesterday I have also brought to the notice of this honorable court the judgment of the Supreme Court where 10 lakhs cost because of the false affidavit which was false. But if the affidavit is false, which is 10-10, how can you throw any paper and the court that is para 28? That's yes, para 28. How categorically the court has come down, heavily come down upon the false affidavit. Sanctity of affidavits filed by parties has to be preserved and protected at the same.
From BOC.
Yes, my lord, seemed, no. This is seemed BOC India Limited. Correct, man. Correct. 28.
That you have read yesterday.
Yes. I don't want to waste time.
Yes.
My lords. So, my lords, the so-called affidavit now is being filed yesterday doesn't tender any apology for the false affidavit which has been filed. And secondly, my lords, it is not required because of the fact at the time of renewal of the application for renewal, the member was alive, he was made dead. I don't know how the ghost will be there to sign the application.
All right.
Matters. That's all matters.
Mr. Pari, do you have anything to say?
My lord, I am coming to the initial affidavit filed, counter affidavit filed by us. In that counter, we have taken the ground
through Mr. Jogendra Prasad Oja, this affidavit.
Now he got superannuated.
That is your first affidavit.
That is he is superannuated. That's why another person is and as under secretary. He is taking all this.
So anyway, the affidavit has been formed by Mr. Jogendra Prasad Oja.
Yes, that time you are there.
You are referring to your first affidavit.
Yes,
that is the first affidavit.
That affidavit I am referring to.
All right. Yes. What
Well,
is there?
straight away I am coming to the minor to the paragraph. Let's come to the paragraph. It starts from page 6, paragraph 10.
Yes.
That may I am reading my lord. 3.14, paragraph 10. With regards to the environment in paragraph 3.11 of the writ petition, defendant submitted that the averment made by the petitioner are all false and misleading. It is submitted that the petitioner applied for the renewal of registration under FCI 2010 and 22/4/2021. The application for renewal registration was denied on 15/4/2022.
It is submitted by the petitioner. This is applied for the renewal of registration on 22nd for 2021. And you took 1 year, that is almost after 1 year, you rejected it 15/4/2022.
No, the renewal.
It is your statement, Mr. Pari. They filed the application in 22 second
So we are
April.
denying the same. What environment they have
No,
taken?
the application for renewal of the was denied
It is-
on such and such.
It is your submission. It is submitted that
It is
petitioner
submitted,
applied
yes.
renewal, it was rejected on so and so. So how can you deny it? You are stating that.
That's
Yes.
why you have taken the
Yes.
particular environment in this our counter reply.
Hmm.
And however, no application renewal of registration dated 24/5 has been received from the petitioner. Further, the abandonment of FCRS certificate of the petitioner expired on 30th October 2021 is hereby denied by this subject party. This specific stand we have taken. The lordship may come to the straightway. I am coming to the same page. May I come into the
No, who claimed that the application was filed on 24th of May 2022? The petitioner?
Yes. They have submitted that they have submitted application on 22/4/2021. It was not denied. It is a
No, it is you have not done it, but subsequently you are seeing the application filed. No application was filed on 24th of May.
we have denied this next page, Lordship may see.
No, have they
However,
stated that
no
they filed?
application of my lord.
Have they stated that they have filed?
They have stated.
3
Where? Paragraph 3.14. Let's check that. May I read the 3.14?
Yes.
Page 7 of the repetition.
No, that is this after your rejection, there is application was filed
Yes,
in the Ministry of Home Affairs.
my lord.
The revision.
That on 22/4/2021, the petitioner applied for renewal of certificate for receiving foreign contribution to the Secretary to the Government of India, Ministry of Home Affairs, Foreign Divisions, FCTS Wing, Major Nandal Savan National Stadium, India Gate, New Delhi. As the certificate for foreign contribution was expired on 30th October 2021, the petitioner and the same was refused on 15/4/2022. And the petitioner applied in Delhi for renewal of the application on 24/5/2022 in the office of the Minister of Home Affairs, Foreign Division, such and such. Copy of the FCL is the Annex 14. That was denied by us.
All right.
Then Lordship may come to this same page 7. After 7 lines of this paragraph, that the validity of the FCRA certificate was further extended up to 31st March 2022 by public notice nominated.
Just 1 minute. Mr. Rai, just 1 minute. Mr. Rai, come to paragraph 3.15.
1/5. Yes.
Uh,
Revision petition I filed and that has been rejected also.
No,
Yes.
is there any provision under section 33 for filing?
Yes, yes. There is a provision.
Just
Yes.
read kindly the
Power
33.
of revision in 32, man.
That is why they have always.
Nomenclature will not determine.
That is all. That is a
Yes.
separate issue.
Yes.
But you have stated is filed in 33. All right.
Yes.
You meant to say it is a revision petition. and
Yes.
it will be covered
That
by
has
the-
been also rejected in 23 matters.
All right.
Yes.
We are denying that we have not received the same.
All right.
And this paragraph, para 7,
You rejected as well.
I read it completely.
What is the rejection order? Have you annexed?
Annex of 1 matters. There is one line out.
That is the first application.
Yes, yes.
Divisional rejection order.
Rejection order matters. After filing of this petition, it was released.
Copy I am asking you.
Its copy has not been,
Do you possess a copy?
copy is not there, madam.
All right.
Copy.
All right. And they say they have not recently received.
No, not really.
Sister is there. I'll ask.
Renewal there is not.
No,
We have no revision
application.
application.
Oh,
It has been rejected, na? You have to copy. Huh? Yesterday you sent me na. Sir, 1 minute. Sir. No. Your revision petition you sent yesterday rejecting their application stands disposed of rejected like this.
No.
I have got it. The telephone also I have got it. Yes. Now I have got it. Lakshmi, I have got only one copy. I am sorry, Justice Rath. As per order dated so and so, remarks column, Lakshmi, kindly see. Remarks column.
That is not relating to the revision, Mr.
Yes, they have said that just it is rejected.
You have not read the order.
Yes,
You have not read the order.
balance.
Yes, and the application for renewal of the FCA certificate has already been disposed of. Of this FC6C application, which has been submitted prior to the renewal application, has become infructuous.
Yes.
Hence, this FC6C application stands.
The revision as so far as the order, they say that they have not received the revision application.
No, they have not received. Because revision application cannot be filed before the order of rejection. This is clearly they have stated this application you have filed before the order of rejection.
You will see my revision application, annexer 15 at page 114.
Yes.
We're denying 24th May, my lords. 22nd May.
24th May.
After again, after the rejection.
In Delhi. Yeah.
In Delhi. That is there, my lords. Can I bring to a kind notice, my lords, the revision application which was filed in Delhi?
That is your case. You filed the Ministry of Home Affairs.
Yes, Lords, you may kindly see that. Now they say that we have not received. Lords, you may kindly see.
Because you also do not have any acknowledgement.
No, I have this. My lords. Lords, you see. There is a stamp endorsement. First page.
No.
If I am correct, my lords, I'll stand corrected, my lords.
Mr. Pari, how many times you are making false statement before the court? Just see the stamp of your ministry. And those who are acquainted with how the South Block functions, they know there is a central registry.
That is annexer we have. Lakshmi, see.
No, just see you are making a statement without this verifying the records.
How can you have an annexure that you have not received?
Its stamp is there, but what is that?
Another one field of the comments and request that.
All right, now just proceed.
Yes.
You have checked up the record, you take this. Just take.
I'll get the Xerox and submit it to your lordships by today, my lords. This revision, I'll get it Xerox and submit
By today,
today, my lords.
within 5 minutes.
Huh?
Send somebody.
Somebody will get photocopies within 5 minutes. You deposit.
Yes.
I've seen that I've verified the same. It was just stapled in this first paragraph. And this page is written 66. But the last page is up to 60.
All right, we'll take care of
It is there, committed must have some application.
Last 30 years, you are not visiting any government office. That is the thing that is making such.
No, my lord, what I'm saying, it is not the acknowledgement of this revision application. Revision application is different. They have application, other provision. They must have submitted some application or the thing. They must have the same.
All right.
As regards the revision part is concerned, the page is 66 this is there, and this page is 60. It's happening, my lord. I am not denying the same. No. Here the case, let see, in revision application, they are not going to give this
Mr. Pari, in a counter affidavit, you have denied.
We have denied now. Still we have denied.
All right.
Because we have no, I have no record in this.
May I proceed by law?
Yes, yes.
But at the same page, this page 7 of this application. This after this 8 lines, the validity of the FCRA certificate was
Where are you reading? Counter affidavit.
Page.
page in our counter affidavit that page 7. The same page I am just continuing my
Counter.
Yes.
The validity of the FCRA certificate was further extended up to 31st March 2022 by public notice dated 31/12/2021 and up to 36/2022 or till the date of disposal of the renewal application, whichever is earlier, by public notice dated 24/3/2022. Since the debitor's FCRA certificate was in the admit of aforementioned public notices, the validity was extended till 36/2022 and till the date of disposal of the renewal application, which is earlier. This we have the annexed documents, my lord. This is annexure A by 1 and B by 1. Then, my lord, Lasime, come to the revision. Lasime has gone through it. Page 8, paragraph 11. We have denying that the revision application and we have quoted this provisions. This alternate remedy is there.
Okay.
That was already enlightened, my lord. The Lasime case to para 9. It is submitted. There is no. May I read, my lord? Last paragraph. Paragraph 9. It is submitted that there is no record or any revision application having been received by the opposite party. Further, the purported application under Annexure 15 also does not reveal requisite fee having been paid by the petitioner. There is a provision of deputing the fee for submitting the revision application. That was also have denied that no such fees has been deputed for the same. And the averment made by the petitioner in these paragraphs are self-explanatory. All these things were. Then Lasime straightway come to this paragraph, when page 11, paragraph 16. Last paragraph is just important. It is submitted that provided to section 12(5) also provides that the central government may not communicate the reasons for refusal of the grant of certificate or for not giving prior permission to the applicant under this section. In this other, there is no obligation to give any information or documents.
Which paragraph?
I am reading, my lord, paragraph 16 now.
16.
16. Page 11 of the reply, my lord, counter.
Yes.
Then, my lord, this page 12, it is submitted that I am just reading the.
Yes.
It is submitted that inputs received from the field of inquiry officer, field inquiry clearly revealed that the petitioner has violated the provisions stipulated under section 12(4)A IB and 12(4)F of the FCR 10. The inputs received from the field inquiry is conducted in the clarified
Document with classified grading.
Just wait. Let him complete.
Yes.
Furthermore, field inquiry is conducted by Central Security Agency, which is exempted from RTI Act 2005. Its term of section 24 of the RTI Act. Hence, the field inquiry report is exempted from the disclosure under section 24(1) of the RTI Act 2005. It cannot be shared in the public domain. Hence, the contention raised by the petitioner in these paragraphs are not at all. That's why my lord is called for the records and we are the records. Now I'm straightway coming to my lord. Yeah, it's affidavit. Next affidavit was filed by additional affidavit. Then let's come to the. We have already covered this paragraph 5, my lord, page 3. Then let's come to the page 6. Paragraph page 4, paragraph 6. The findings of the field inquiry further reveal that lordship got it, my lord. Additional affidavit. Further reveal that the petitioner has diverted the foreign contribution for undesirable purposes and involved in the activities other than those permitted in the FCRA registration certificate, and also contrary to the aims and objectives mentioned by the association in its memorandum of association. For the sake of convenience, the aims and objectives as per the memorandum of association submitted by the petitioner are as follows. To give training is also repeated in the next affidavit also. To give training to the education to all around the development of the mentally handicapped and to regulate these in order to make them socially accepted citizens irrespective of their caste, creed and community or region. To be undertaken, establish such and such it is given. Then lordship may straightway coming to this paragraph 7 in the page 5.
Yes.
It is submitted the petitioner association is registered under the FCRA for such and such social purposes, and the petitioner's association applied for the renewal registration for social and educational purposes. However, from the findings of the field inquiry report duly produced before the Honorable Court on 17/4/2022, it is humbly clear that the petitioner has diverted the foreign contribution for religious agenda and involved in the activities contrary to the aforementioned aims and objectives and prejudicial of the natural interest and as such national interest and as such violated section 8(1)(a) and 12(4)(a) and 4 and such and FCR 2010. The relevant parts of the aforementioned sections are produced before then we have quoted the section. There is no need to place before my lord. Then I am coming to our next affidavit, my lord. Yes. In that affidavit, we are admitting last occasion, my lord has made a query about the debt. We are admitted that the debt which was in 2020 and 2021, the 2021 is correct. Our field inquiry report is given involuntarily and it was clarified in the affidavit. But simultaneously, we are saying that this rule 17A was not complied with, for which even though they have submitted application and I'm just coming to this, my lord, in the internal page 3. I have page 2, my lord, paragraph 5. That with regard to the environment in paragraph 2 to 7 of the original affidavit, the deponent respectively submitted that the contention raised by the petitioner in these paragraphs are misconceived and misleading. It is submitted that as per the inputs provided by the field agency regarding death of the sister Manatha Roji Anthony, Vice President, the death of the April 2022, which was where I admitted it is a mistake. Then let's come to the last subsequent paragraph. At this juncture, it is submitted that the petitioner was in knowledge regarding the death of sister Manath Ashwini Anthony and as admitted by the petitioner in this rejoinder affidavit. However, despite knowing this facts, the petitioner did not give any intimation to this opposite party regarding the death of the aforesaid member and never applied for the change in key members in statutory form FC6E and failed to meet the statutory requirements. In this regard, the relevant rule 17A of the foreign contribution regulation such and as amended by notification number such and such dated 10 November 2000 is produced below. 17A. the change of designated bank account name, address, aims, objective, or K, such and such, or key members of the association. He is the key members of the association who is died. A person who has been granted a certificate of registration under the section 12 or prior permission under the section 11 of the Act shall intimate in electronic prior permission under section 11 of the Act shall intimate in electronic from within 15 days of any change in the following name. So now it was amended for 45 days, but in that period it was 15 days. Even to presume that in the 45 days, we didn't submit the application till then. And the office bearers or the IV or what my clause IV, office bearers or K functionaries of the members mentioned in the application for grant of registration or prior permission or renewal of registration, as the case may be, in form FCCE, which was 6C. It was not provided that the change shall be effectively only after the final approval by the central government, which has not been done. It is submitted that the Rule 17A has been further amended by notification of such and that for 15 days to 45 days. So we have attended even though 45 days they are accepting it or not. Then, my lord, it is coming to the paragraph, next paragraph. This 37. The penalty for offences where no separate punishment has been provided. Whoever fails to comply with any provisions of this Act for which no separate penalty has been provided in this Act shall be punished with imprisonment for a term which may be extended to the 1 year or with a fine. So once a person is failed to submit 70 year or comply anything with the statute, he not only he has given insufficient of records or documents, suppression of facts, he is also punishable under the provision for according to the 37, the penalty provision 17A is there. And that's why we have annexed the copy of the same in this affidavit. Let's come to the paragraph, page 13. It start from page 12 onwards. Let's got it page 12. It is serial number 13. In the said rules, Rule 17A, very small it was written, my lord, I'm sorry, it should be enlarged. This said rules in Rule 17A, for the opening paragraph, the following paragraph shall be submitted, namely, substituted, namely, a person who has been granted a certificate of registration under section 12 or prior permission under section 11 of the Act shall intimate the electronic from within 15 days or any change in the following, namely, for clause 2, clause and IV, the following shall be substituted, namely, IV, the office bearers or key functionaries or members mentioned in the application for grant of registration or prior permission or renewal of registration, as the case may be, in form FC6E. It is mandatory. Then she may come to the, I am not taking another time, my lord. This it is a compounding offence, non-compounding offence. It is a compounding offence. Is written. Then Lordship may come to this amended. It is 45 days. Page 15 I have given. Then this form of page 16. Form C I have given, my lord. Just page 16 FC-6E. See Rule 19 and 17A. It is addressed to the Government of India, Ministry of Home Affairs. Then Lordship may come to the paragraph 4. To be paid by the applicant, given intimation regarding change of the original K members of the persons association. Details of payee K members of the persons association after change the original K members as reported in the application for grant of registration, prior permission, renewal of registration of the person association under the foreign contribution regulation such and such. Then they have given the details to the paragraph. Then Lordship may come to straight with the below line. I/we name of person associated, hereby affirm that the information furnished above is true and correct. The resolution, the resolution of the governing body has been passed before effecting the changes. B. None of the key members has been appointed in violation of the subsection subclass 4 of section 12 of the Permanent Contribution Rules Act 2022. Everything it is mentioned, it was well known to the person who is taking foreign aid or any contribution in this regard. They are very well known what is my limitation. If you will take the contribution from foreign aid, what sort of documents you will submit, and we have to disclose by fairness that if a person is in diet, so he has submitted application, there is no dispute that he submitted application such and that. But within 15 days, they have to submit the application, such and such application has been, a person has been died, for which I am submitting the FCC form. That was not been given, for which the 17A of the rule 17A is invoked to him. And only lastly, I am just I am just enlightening my lord. Para 7 of the same affidavit,
Yes.
page 7, it is submitted that, may I read?
Just a minute. Yes.
Yes. It is submitted that the petition resolution, it is submitted the petition resolution is registered under the FCRA 10 for social purposes, and the petition resolution applied for renewal of registration for social and educational purposes. However, from the facts mentioned above and further in paragraph 68 of the additional affidavit, it is amply clear that the petitioner has diverted the foreign contribution for religious agenda and involved in the activities which is contrary to the aforementioned aims and objectives and prejudicial to the national interest, and as such violated section 8 subclause 1A and such of the 12 before the FCR Act. Therefore, the renewal application of the association was denied on 15/4/2022 under section 16 subclause 1, read with section such and such. Hence, it is evident from that this party has acted bona fidely with the due diligence and the rejection of the renewal application of the petitioner by this operator due to violation of the above mentioned provisions and this is under section such and such. So, my our humble submission for my lord is that this is the organization who is come forward before my lord. He should come with a proper application and with all cleanness. What allegation they are enlightening to us as regard to the false affidavit, whatever thing is there. Whatever mistake was committed, we have filed affidavit also clarifying the same. Yes, it is our mistake. Rightly, it is reciprocal to them also. Suppose any mistake they have committed, they should come with a clean hand and submit to authority concerned that, because the regional power is there. They are saying that we have submitted the regional application. We are denying this, we are not receiving this regional application. Whatever staff, all these things, they are showing that they are not filing affidavit, all these things. They are not coming with all these things. So here, norms also recording statement, my lord.
They have filed the affidavit stating that we have filed the revision application, though section has been wrongly mentioned.
My lord, which was in our record, there is no acknowledgement, and they have not declared fees. Is required to report fees. Statutory fees required to be somewhat report for revision application.
Under which rule?
This is there in the revision application 32. Let's make
No, 32. No, where this payment has to be made for filing the revision application. What is that provision?
This 32. What 32 says? I'm just verifying. We have taken that stand in our counter that in the revision application they have
show that such a revision,
my lord.
Regarding the registration, also the stamp is required.
Idiot. That's 17. Oh, it is, sorry, sir. My lord, 32, I'm just reading. 32I, the central government may either of its own motion or on an application for revision by the person registered under this act, call for and examine the records of any proceedings under this act in which
Sorry, my question is very, very focused.
as regard to the statutory fees.
Just state that line that this is the deposit has to be made along with the revision petition. Yes.
If let's see if to keep it after long, then I can clarify this point.
No.
But we have in the affidavit we have taken this stand. As regard to the
Reference to any rules, any regulation.
yes, then must have. Otherwise, Government of India cannot go.
From the-
They cannot accept the fees.
From the wording of annex of 32, because you can also take it on your own motion. So where is the question of fees? Central government may either of its own
Either
motion
one,
or
either
an
of, yes.
application.
Only that like a revision of the order by the central government, but nothing has been made about this on application. Either a summary court is saying. Well, I will check it up, and then I will clarify, my lord. If there is, I will catch it. If it's not there, I will. My lord, I'm last conclusion of my argument is that
Yes.
the recently and judgment of the Honorable Supreme Court to be by the central government.
To describe.
We can see but the person implementing the outing will be in knowledge. Permission. The fee will be revised. The root of the city. Right.
Yes.
Well, I'll check the rules is with me. I'll check it and come back within 5 minutes to the ever.
There is a power to frame the rules for purpose of payment of fees, but our question is whether such.
Yes,
rules-
Lordship is right. They have given different fees in different purposes. I'll just check out whether this for the purpose of revision, whether any fees has been determined or not, or what is the procedure. I'll just clarify. With regard to the my law, the decision of the Honorable Apex Court. I'm just passing these two judgments. Thank you. Other side, go ahead.
Yes.
It is in 2023 volume 3 SCC 544. Sir, it is Noel Harper and others, but Union of India and others. This a share concern. I am straightway, my lord, let's may come to the page 567. Sorry, 566. Paragraph 22. Mary is the core intent behind the provisions of such a section of 12A is to facilitate the proper identification of person and association with which the persons are connected and also purposeful real-time monitoring of activities for the ensuring that the same are not detrimental to the national interest. As a matter of fact, in 2010 Act, it itself mandates that the benami and fictitious activities are prohibited under the Act. Those from proper identification of person at the time of registration would ensure proper identification of functionaries of the FCRA NGOs. Such a provisions ought to be stand that the test of legitimate aims and also proportionately test. Then, my lords, come to the same page, paragraph 25. It is further stated that in 2010 Act and the mandates of the Ministry of Home Affairs, Officer MHA, to regulate the receipt and utilization of the foreign contribution in the country. That process involves multiple steps, including audit, inspection, and filing of annual returns and monitoring of fund flow. Accordingly, a systematic monitoring of FCRA bank account is imperative part of the regulatory measures provided in the Act and the rules made them thereunder. It is alleged that presently there are about 22,600 NGOs are holding registration or prior permission for specific project programs. The NGOs use the receiving the foreign contribution in the exclusive bank account for their choice in any bank in India. That result, the opening of multiple accounts in hundreds of branches spread across the country. This inevitably caused enormous difficulty in monitoring the inflow of or outflow of amount for the respective sources. I'm just enlightening this. Then let's may come to the C, the same paragraph. It is asked that the legislative intent behind the 2010 Act and the objective ought to have achieved is to be curb misuse of foreign contribution, the threatening of sovereignty and integrity of the nation, including the imperating of the polity. As aforesaid, the amendments were necessitated on the account of past experience and to curb them.
How these propositions are relevant in the proceedings?
Why I am highlighting same?
There is nobody's case.
This is a case where what is our allegation is that on inquiry report is found that the purpose of those memorandum articles, what they had purpose, they're taking contribution. It was not utilizing for that purpose. At a happened another. So once it is diverted, this we are handicapped, we cannot process their application, we can give registration. This is only told. That's why I'm saying, let's may come to the page paragraph 29. Paragraph 29, it is page 568.
Only.
That is also a relevant. Reliance is also a pledge such and such. restraining the above principle and observation that the court will not sit in a appeal over the policy of parliament in enacting the law, it is different. So it is not
law was challenged.
Yes.
Perspective.
Yes. Then my lord may come to the statute. This they have discussed about page 590 about 12. Grant of certificate of registration. They have quoted it. The same thing was dealt with. Then Lassi may come to the page 592, the power of central government. There is honorable court also, the apex court also discussed this. About this.
Yes.
Then also the apex court decided 598, you see the section registration to utilize the foreign countries, the power of central government to provide the same. Then Lassi may come to the page 99, para 96. The provision of chapter 3 dealt with the subject registration. Subject to 11, it is about the registration of certain purposes with the central government. Section 12 is about grant of certificate of registration and the purpose of registration. Then Lassi come to the same page 600, paragraph 13, 106 has the cancellation of certificate. It is concluded with the, just I am reading the same line. Provision is quoted, so there is no need to read. Then ultimately paragraph 50 it was dismissed. So the apex could also take into consideration all the aspect and discuss very thoroughly and dismiss this application of the petitioner. Basically, this more or less our case is similar to this. So yes, because the same thing, the diversion of fund is a major issue.
Nobody challenges the law here.
My lord?
Nobody has challenged the law here. Here is the only problem that your investigation and the result thereof,
yes,
whether has to be believed by the court or the court will be on believing that to direct you to give them the registration again. That is the issue.
My lord.
If they fulfill all the criteria of the registration, they will give, otherwise you will not give.
This is, yes. My lord, as regard the fees revision provision, Lassi may see the Rule 20 revision. An application for revision of an order passed by the competent authority under section 32 of the...
It was in the rules. 2011, FCRA rules.
I'll provide this. I'll give a copy.
That is the power you can impose fees, but whether you can impose fees,
is there.
why is there fees?
Yes, there. I'm just reading, my lord. An application for revision of an order passed by the competent authority under section 32 of the Act shall made the secretary to the Ministry of Home Affairs, Government of India, New Delhi, on a plain paper. It shall be accompanied by the fee of 1,000.
Yes.
In the form of demand draft or the bank checks in favor of the pay and accounts officer, Ministry of Home Affairs, payable in New Delhi. The rules provides.
But they
didn't depute the same. And we are saying that neither the fees are deputed nor they are submitted to the revision application. This is the issue.
All right.
Yes, madam.
Yes.
I have paid the fees at the time of filing the revision application, 3,000 rupees. And I can also demonstrate the 3,000. Lassi may kindly record my statement.
Nothing is completed in pleading. In pleadings, they are not giving anything. Whatever thing they have deputed, only they have given the revision paper. It was stamped by the organization itself.
Yes.
Neither the acknowledgement nor about the fee they have reported what their my senior is submitted to the court. Nothing has been disclosed in the pleadings. Now, no record in the filing this regard.
Because they have not disclosed, you have denied. Had they disclosed, you could not have denied.
No, if there is an authentic document, how can you deny? It
No,
cannot.
but you have denied without verifying.
No, we have verified that our record saying that nothing has been filed. No report has been submitted.
Very well.
See, if they filed the affidavit, we can examine that same.
My question is that if you take the plea in the one hand, the revision petition was not filed.
My lord.
Can you take the plea on the other hand that the appropriate fee was not deposited?
For depositing the revision application is required to deposit the statutory fees,
That is
which was not been done by them. Not only we denied that they have deposited the fees.
No, you have not denied that they have deposited the fees. You have not denied.
We have taken the plea.
Where?
Yes.
Counter.
In counter, we have said so.
No,
Page.
additional affidavit.
The additional affidavit or said so.
Yes.
Additional affidavit you cannot, and that too, Lordship may record my statement that I have deposited rupees 3,000 rupees. That statement may kindly be recorded.
Additional affidavit on behalf of the opposite party, paragraph.
This is a new affidavit. Report there. That's all, Mr.
Yes, yes.
All right. Take down. Heard Mr. Siddharth Rai, Medicinal Council, issued by Mr. Who is
My lords, my associate has gotten a bereavement, so therefore he couldn't come in the family.
Only let them be only once.
Mr. KK Sahu, Lordship may record.
Mr. KK Sahu.
No, that's absent today.
No, this, someone can assist you. Who is there?
Not signing the Bhakla Tama.
No, just, I mean, just say.
Mr. Mahanti is there, Adhiraj Mahanti.
Mr. Udhiraj Mahanti on instruction of Mr. KK Saul and counsel for the petitioner. And also heard Mr. PK Pari and Deputy Solicitor General of NDA along with Mr. B.S. Rajguru, Learned Raiguru, Learned Central Government Council. By means of this writ petition, the petitioner has challenged the order passed by the Secretary, Ministry of Home Affairs. By rejecting the renewal of petitioner's registration for receiving the foreign contribution under the Foreign Contribution Regulation, within Bracket Regulation Act 2010. The said order of rejection of renewal dated 15/4/2021. It is 2021 or 2022? 2022. Are you sure?
Yes, madam. They have themselves said, and also
No.
Annexure 1 at page 23, madam. That mail. 15th April, the time is there, page 23, 12:49 PM. It is written. That's a mail. Has been refused. The renewal application has been refused under section 16(1), read with 12(4)(a)(6) and 12(4)(f)(6). of Foreign Contribution Regulation Act 2010. Annexure 1 at page 23, Lordship will see 15th April, the mail came. My Lord Chief Justice got it.
Yes, I'm trying to, because they have made a statement.
Yes, yes.
This what is the line you have to. 15/4/2023 has been challenged by the association. According to the association petitioner, according to the petitioner within comma, Messrs. Ashok Kiran Charitable Society, a society registered under the Societies Registration Act, having its registered office at Dipupara, Jharsuguda, Orissa. Stop. According to the petitioner, no reason has been disclosed by in the said order dated 15/4/2022 why their application for renewal has been refused under application for renewal under section 16(1) has been refused. 16(1) read with 12(4) within bracket 4 within bracket small a, close the bracket, and again open the bracket, Roman small c, close the bracket, and section 12(4) within first bracket, close again F, close the bracket within bracket Roman 4 of the Foreign Contribution Regulation Act, in short FCRA. The petitioner is engaged in charitable activities and they are running
Home. We are running a home, my Lord.
No, I'm just searching out the para where you have stated. So
Yes. Para 3.2, Lordship may kindly see. Page 3.
running a special school for the mentally challenged person by giving them training for the holistic development, by early intervention activities, behavioral modification, psychological, physical, and vocational training to make them the dignified human persons. For that purpose, they have been receiving the foreign fund after obtaining the certificate under section 16. Under section 12. Of the FCRA. It has been stated by the petitioner that they uploaded the application for the renewal in the designated portal for renewal of their certificate for a period of 5 years. And the said application was made in form FC4 in terms of the foreign contribution regulation rules, in terms of the Rule 17 of the foreign contribution within bracket regulation rules 2011. By a one-liner order dated 15/4/2022, order thereafter annexure 1 to the petitioner, their renewal application was rejected. It has been stated by the petitioner. Thereafter, they filed the revision petition to the appropriate authority, i.e., to the Ministry of Home Affairs, FCRA wing, on 24/5/2016. Along with all the material documents, including the audited accounts within bracket FCA for the year ended on 31st March 2020 by chartered accountants. The face of those allegation of arbitrariness, the opposite parties, while their counter affidavit, firstly on 9 February 2023, stating that that the central government may not communicate the reasons for refusal for grant of service or for not giving prior permissions to the application under section 12(5). In cases where there is no obligations to give any information or documents or records or papers under the Right to Information Act 2005. So, thus, the opposite parties have accepted that they did not disclose the reason for a refusal of renewal of the FCRA certificate. In the said affidavit, the opposite parties has made the following amendments. Para 10. That with regard to the amendments made in paragraph 3.14 of the writ petition, the deponent humbly submits that the amendments made by the petitioner are all false and misleading. It is submitted that the petitioner applied for the renewal of registration under FCRA 2010 on 22/4/2021. The application for renewal was denied on 15/4/2022. However, no application of renewal of registration dated 24/5/2022 has been received from the petitioner. Further, the amendments that FCRA certificate of the petitioner expired on 30th October 2021 has been denied by the opposite party, is hereby denied by the opposite party. It has been further stated in the said counter affidavit. So, the petitioner FCRA certificate was in the ambit of the aforementioned public notices, the validity was extended till 30/6/2022 or till the date of disposal of the renewal application, whichever is earlier. Therefore, after 15/4/2022, the petitioner's society did not have any valid FCRA registration certificate for accepting foreign contributions or funds. So, according to the opposite parties, Section 32 of FCRA provides the scope of revision of the order passed by the central government. So, as such, it has been contended that no such revision petition was ever filed by the petitioner following the prescriptions of Rule 20 of the FCA Rules 2011. For purpose of next renewal of the registration certificate for purpose of renewal of the FCRA certificate, every person who has been granted a certificate under Section 12 shall have such certificate renewed within 6 months before the expiry of the period of the certificate. provided that the central government may, before renewing the certificate, make such inquiry as it deems fit to satisfy itself that such person has fulfilled all conditions specified in subsection 4 of section 12. Section 16(3) has provided the maximum period for taking into consideration of the application for renewal. It provides that for renewal of this certificate, the application for renewal has to be disposed of within 90 days from the date of the receipt of the application. So, there is no dispute that the application for renewal was disposed of. So, it has been further contended by the opposite parties that proviso to section 12 within 5 also provides that the central government may not communicate the reason for refusal for grant of certificate, as stated before. Thereafter, the opposite parties has contended as follows. It is submitted that inputs received in the field inquiry clearly reveals that petitioner has violated the provisions stipulated under section 12 within bracket 4, close the bracket within bracket small a, close the bracket within bracket 1 small 4, close the bracket, and 12 within bracket 4, close the bracket within bracket small f, close the bracket, open the bracket of 6, close the bracket of FCRA 2010. The input received in the field inquiry is a document with classified grading. Furthermore, the field inquiry is conducted by the Central Security Agency, which is exempted from the RTI Act 2005 in terms of section 24 of the RTI Act. Hence, filed inquiry report is exempted from disclosure under section 24(1) of the RTI Act 2005. Appeared in the public domain. As the contention raised by the petitioner in these paragraphs are not at all sustainable in the eye of law, or with the same are liable to be rejected. It has been further stated that since there is an alternative remedy under section 32 of the FCRA, this writ petition should not be allowed to be maintained. So, the opposite parties has filed another counter affidavit in the form of styled as additional affidavit on 9/5/2023. In the said affidavit, they have contended the same thing regarding the field inquiry. But they have diluted their area of objection when they have stated that The findings of the field inquiry further revealed that the petitioner has diverted the foreign contribution for, quote, undesirable purposes and involved in the activities other than those permitted in the FCRA registration certificate, and also contrary to the aims and objective mentioned by the association in its memorandum of association. Stop. For the sake of convenience, the aim and objective as per the memorandum of association submitted by the petitioner are noted in the said additional affidavit. Stop. Those are as follows. Page 4, A, B, C, D. Just go to the A, B, C, D up to G. Stop. It has been also asserted in the said affidavit that the findings of the field inquiry report has been produced before this court on 17/4/2022. So, according to the opposite parties, the petitioner has diverted the foreign contribution for religious agenda and involved in the activities contrary to the aforementioned aims and objectives and prejudicial to national interest, and as such, it violates Section 8 and 12 of FCRA Act. The relevant parts of the the on 10th of August. No, it is not 10th. You filed it in the September. Or it's
Yes,
not.
8/9/2023.
Huh?
8/9/2023 date.
Uploaded on the date?
Final?
On that date you uploaded this thing.
Okay, we will see date of the 8/9 date.
No, 8/9/2023 is the date of
No,
affidavit.
uploading, date of uploading.
Date of uploading on yesterday, Monday.
No, but
Monday.
Monday.
Yesterday. On 11.
Another response affidavit was filed by the opposite party on 11th September 2023. So, it is to be mentioned that in the affidavit, filed on 9th May 2024, a serious allegation has been made that one of the functionaries of the said society that is the main affidavit, I think.
Annath Rosie Anthony, ma'am.
So which affidavit they first said it?
Yes, that is the first affidavit in the month of this September they have said. That time. Para 5, my lord, that is dated 15/5/23, which was served only September. It's submitted as
in this 19.5, no? 19.5/2023. The opposite party has asserted that as follows. Quote para 5. Stop. In view of this so-called information of death, the opposite party has taken a stand that the application for renewal was filed by a person who was in the name of a person who was not alive. But in the affidavit dated 11th September 2023, the opposite party has accepted that the said allegation was incorrect and the said allegation was made on the basis of a field inquiry report. It has been also stated in the said affidavit dated 19/5/2023 that as per the inputs provided by the field agency regarding death of Sister Manath Rosie Antony, Vice President, the date of death was April 2022. And basing upon the same, the opposite party had filed a counter as well as additional affidavit. So, but when the query was made from the field agency, after receipt of the rejoinder affidavit within third bracket filed by the petitioner, close the bracket, especially with regard to the death of Sister Manath Rosie Antony, Vice President, the field agency submitted a report reflecting the date of death of Sister Manath Rosie Antony on 19/4/2021. Stop. And it has been admitted by the opposite party that the application for renewal was filed much before the death of the said Sister Manath Rosie Antony. Now the opposite party has raised another plea that despite knowing this fact of death, the petitioner did not give any intimation to the opposite party and never applied for change in key members in the statutory form FC6C and failed to meet the statutory requirements. In this regard, the relevant rule, in this regard, the Rule 17A of the Foreign Contribution within First Bracket Regulation Rules 2011 has been referred. The Rule 17A 4 is within Roman 4 is relevant for our purpose which reads as follows, quote, small 4 within first bracket, Roman 4. Office bearers and the key functionaries or the members mentioned in the application for grant of registration or prior permission or renewal of registration as the case may be in Form FC, Form FC says 6E. Stop. The opposite party therefore has stated that when one key person, a functionary, has passed away, it was the duty of the petitioner to bring the said fact on record and also to fill up the post that has been vacated for the untimely death of the said vice president of the society. Stop. It has been also stated that it has been reiterated in the said affidavit that the petitioner has diverted the foreign contribution for undesirable purposes and involved in activities other than those permitted in the FCR registration certificate, and also to conflict to the aims and objective mentioned by the association in the memorandum of association. So the aims and objects already reproduced. So, therefore, the ground for denial has been clearly stated now in the public domain by the opposite party by their affidavit dated 19/5/2023. So, there is no dispute that the petitioner applied for renewal of the registration for social and educational purpose. But according to the opposite party, the foreign contribution they had received on the strength of the FCR registration certificate, the petitioner had diverted that fund, quote unquote, for religious agenda. Stop. Even though the petitioner has submitted their audit report with the application, the opposite parties have failed to show which part of the same contribution has been used for the religious agenda, quote unquote. So, even there is no murmur against the audited accounts. Filed in with the application in Form FC4. So, Mr. Royal Understanding Council, referring to the petition, has submitted that the foreign contribution that had been received by the petitioner has been used for the same special schools and upbringing of the mentally challenged children who are giving education and training for their growth as able human beings. Stop. As stated in the counter affidavit by the opposite party, in terms of our order dated March 2023, the opposite party has deposited the field inquiry report under a confidential sealed cover with a note marked quote unquote secret. We have perused that short note where it has been further stated that Manath Rosie Antony is fictitious as he died in April 2020. Further, the association runs a church / prayer hall within the school premises. The students of the school are allegedly made to attend the prayers twice a day. Running a church violating the nature of association. We have carefully examined the report, which has been referred to in the counter affidavits filed by the opposite party as the field report. There was only one objection that has been raised in the
I may be
report.
pardoned, my lords. I may pardon. I call from other court.
No, let me go. What is the which is only objection that has been raised in the said report is at Paris 6. Stop. Since closed by the opposite parties in their affidavit, we do not find any justification to maintain this sealed cover procedure. So in Paris 6, their objection is as follows. So, it runs a church / prayer hall within the school premises. The students of the school are allegedly made to attend prayers twice a day. So running a church is violated of the nature of the association. This may be factored in suitably while deciding the matter. So where the core allegation is concerned, i.e. the diversion of funds, we do not find any whisper even the said report. The objection is relating to running a church. Even the note that has been provided to us with the said report does not reflect the any manner fund of for the petition that has been utilized for any religious activities. The only objection so far we could gather is that the petitioners are quote unquote allegedly made the children, students of the school, to attend the prayers twice a day. Stop. Even regarding these regarding the said allegation, even the objection that has been raised regarding making the students attend the prayers twice a day, it has been qualified by the word allegedly. So this is not a verification in the form of the local inquiry. If the facts are verified, that has to be differently stated. On the basis of such unverified local inquiry report, the opposite party has denied the renewal of the FCA registration certificate in favor of the petition. They surprised the way the opposite party had taken objection on the basis of a untimely death of one of the chief functionaries of the society without verifying the date of death. It was asserted by the affirmed affidavit, asserted by the affidavit that the death took place in the year 2022. Later on, the opposite party has, on purported verification, stated that the death took place in 2021 after the application for registration was filed. So for the compliance of Rule 17A of the FCA rules, Rule 17A of the FCR Rules 2020 is concerned. For this, the renewal was not denied. Mr. Pari Lanet Deputy Solicitor General of India has strenuously argued before us that the funding being diverted for the religious activities. But there is not a piece of paper vis-a-vis the audited accounts that was submitted by the petitioner to show that any fund has been utilized for any religious purpose. Mr. Pari Land Council has also reiterated that if the petitioner is aggrieved by the order dated 15/4/2022, they have the remedy in the form of religion under section 32 of the FCR. In this respect, on scrutiny, we find that the petitioner has claimed that they have filed one revision petition on 24/5/2022. But Mr. Pari Land Council has categorically stated on the basis of the additional affidavit, as referred before, that no such revision petition was ever received by the opposite party. At that juncture, Mr. Rai, with the leave of the court, has submitted a copy of the said revision petition, which where is the stamp? Stamp is not with your bunch.
First page, that's will find. First page.
Which gives a stamp of the central registry of the Ministry of Home Affairs, showing that the said application was received on 24/5/2022. Mr. Pari Land Council.
May small interruption. The statutory fees you have taken environment nursing reflect it.
Oh, that I've said on the basis of that you have not received it. Mr. Pari Land Council has referred a decision of the Apex Court in Noel Harper and others versus Union of India and other. Column 2023 3 SCC 544. Stop. In the said litigation, the wives of the constitutional validity of amendment to the provisions of foreign contribution within bracket Regulation Act 2010 carried out by way of Foreign Contribution within bracket Regulation Amendment Act 2020, making a substantive change, was challenged. The said challenge was scuttled by the Apex Court. holding that whatever hardship may be caused to the registered association on account of change, but that cannot be the basis to declare the law made by Parliament invalid. As a Pari Learned Council has specially referred the para 22 of the said decision, holding again that the section 12A mandates that the benami and fictitious activities are prohibited under this said act. We do not find any relevance of referring this said position of the Supreme Court in the present context, as there is no allegation that the petitioner has been carrying on in benami or fictitious activities. At least that is not revealed from the field inquiry report as produced before us. So the question relating to the existence of the revision is concerned, Mr. Rai further submitted without producing any documents that the petitioner has paid fee of rupees 3,000 for the said revision petition. As the opposite party has denied to have received the revision petition, but on record we find there is a receipt seal on the body of the application. We deem that there has been no decision taken by the central government at all. Mr. Roy, Senior Counsel has submitted that the future of the mentally challenged students are at stake for non-renewal of the FCR certificate in favor of the petitioners. No activities of the petitioners can be stated to be anti-national or violative of the conditions of the SCR certificate as was provided under Section 12 of the FCRA. Stop. We have after meticulously scrutinized the field inquiry report and evidence of the opposite party. We are persuaded to hold that no sound reason has been provided to this court to hold that the action taken by the opposite party by refusing the renewal of the FCRA certificate, read Annexure 1, and as consequence thereof, we strike down the decision of the opposite party of not renewing the certificate. So, we would direct the petitioner to reconstitute the society in terms of Section 17A of the Foreign Contribution Regulation Rules 2011 And also file the form FC-6C afresh to the opposite party, preferably within a period of 30 days from today. After receipt of such application, the opposite party shall consider the matter afresh, but keeping our observation made herein above. Such exercise shall be completed by the central government within a period of another 1 month from the date of receipt of the receipt of the application in the statutory form. No new material shall be considered by the central government, and the renewal will be granted from the date when the former FCR registration has expired, so that the continuity of the registration is maintained. In terms of the above, this writ petition stands disposed of. A copy of this order is supplied to Mr. Pari, Learned Deputy Solicitor General of India. Forthwith, urgent certified copy is supplied in proper application.
Annexure 1 is to be set aside, my lords, unless Annexure 1 that refusal order. Yes.
Strike down it already.
Obliged.
The report, this field inquiry report is submitted before us, be returned in the sealed cover through Mr. Pari, Learned Deputy Solicitor General of India.
Obliged, ma'am.
Cover our seal, report seal will be there. So, Pari, what is a seal cover?
Yes.
This is for our
Plus item 8 is small matter.
yes.
Item 8.
Age is saying is small matter that
That is most regarding the filing of complaints affidavit that the disposal of drugs matter. That already filed, signed for the hard copy. The regular orders have been passed.
Call one, just Mr. Ruki, just 1 minute. Huh?
Yes, sir.
What's it? In item 1, my lords.
Item 1, sir.
Item 1, my lords, I'm appearing through VC, my lords. I'm audible and visible, my lords. My lords, before I advert to the merits of the matter, Mr. Jena was appearing, my lords. I may draw to your lordship's attention that one IA we have filed, IA at flag 5. That is on behalf of the association. The association had authorized Mr. Sabindra Jena, who was appearing in person, my lords. On last occasion, he had brought an objection that he did not want to continue to represent the association. Now the association is appearing directly through the secretary, and Mr. Jena has been relieved of the responsibility to appear on behalf of the association. Therefore, my lords, the amendment of the cause title has been sought. Therefore, the cause title the association is now before your lordships as the appellant. So the association, because of the illness of the secretary, had authorized for the time being the Mr. Sabindra Jena. My lords, also an additional affidavit is being filed, bringing on record the health ailment records and the authorization and the revocation of the authorization. Today, my lords, the IA that has been filed, that is at flag 5. IA 6156, my lords. This is a small housekeeping exercise, my lords. I'll request that lordship it may be at flag 5, my lords.
We got it.
Yes, my lords. So we have also enclosed a proposed amendment to the cause title.
Yes, I have filed an application for intervention in this case. If they are going to, they can withdraw and file a separate treaty.
Why will I withdraw this?
When appellant is going away.
I may be permitted to address, my lords, then my learned senior can
How
address.
can it be done? You are addressing, I have a right to also address. I have a right to address.
I'm addressing, my lords. Let me place my application, then my learned senior can come in, my lords.
No copy has been given to us. We have
You
appeared.
need not be served a copy. You are not a party in the case.
I have already filed, filed an intervention
It has
application.
not been allowed, my lords.
The cause title of the writ petition,
Yes.
page 20. It starts from page 20.
Can you stop me from talking? I don't understand.
This is my application, my lords. I am the dominus litis.
Just hold right, page 21.
We know the law. We don't teach us the law.
The petition was filed by Nishchit Ranjan Patnaik. And copy number 5 was the truck owner association.
And 6 is the secretary, my lords.
6 is the Surya Narayan.
Sorry.
Now this writ appeal was filed in individual capacity.
No, not in individual capacity. My lords, have a look at the cost title, my lords. It's a wrong submission. Actually, incorrect submission, my lords.
Your lordship may kindly see the cost title.
Great responsibility, my lords. My lords may have a look at the cost title of the writ appeal, my lords.
How an individual person can represent an association? It's
This is authorization. My lords may have a look at the cost title.
Cost title is
Mr. Even if the association is the association would be the party and the person will represent the association.
My lords.
But here this from the cost title I find he is the appellant, he is typed in and has
My lords may see page 2, my lords. May I have page 2 for a moment, my lords.
page 2 of
The writ appeal, my lords.
all right.
My lord, this is Sabindra Kumar Jenna, such and such address, such and such, authorized on behalf of the Secretary of the Keonjhar District Truck Owners Association. This was an authorization, my lords. I have requested my associate to hand over the additional affidavit. The additional affidavit will indicate that an authorization was given.
No, I am not on that. When you are just filing a litigation
my lords,
for an association is a body corporate,
my lords.
right? This litigation should be in the name of the association, maybe represented by the secretary.
So this is
Go to the society also. The Central Societies Act says that section 6.
Section 6, my lord. Same section 6. My lords.
By secretary or the president.
My lords.
Right, both the chief functionaries, they can do it. But the litigation should be brought under the name of the society only.
My lords, society is there, my lords. Keonjhar District Truck Owners Association, my lords. That's there.
Where is it? Where is the society? In the first title, there's
My
no
lords may see at
society.
the, my lords may see, my lords, at page 2, my lords, for a moment.
Yes.
Sabindra Jenna, authorized on behalf of Secretary, Keonjhar District Truck Owners
You
Association.
are not getting my point.
I got your point, my lords.
You are going above the
My lords,
application.
because there is we found this is a defect that was pointed out. We filed a amendment application, my lords, that is there on record. That is an IA, my lords, we filed. That is the IA at flag 5, my lords.
All right, come to the flag 5.
Yes, my lords.
Yes.
IA 6156 of 2023.
Yes.
Here, my lords, the secretary is seeking to the authorization in favor of the person has been revoked. Therefore, this person has entered appearance. The secretary representing the Keonjhar District Truck Owner Association. Now, the my lords may see the proposed cost title at page 5 of the IA. This is the correct cost title, my lords. That was an
Exactly. This is the correct cost title. There is no disagreement.
at page 5 at the bottom, my lords, at the foot of page 5.
Now, the problem is that you are seeking that amendment of the private individual to substitution, and that private individual is not before us. Whether he has any objection or not, we do not know. Where is he?
Lords, he was authorized, his authorization has been revoked.
There is any objection, the association is coming into this.
ଗୋଟେ ଦରଖାସ୍ତ ଦେଇଛନ୍ତି କି ଆପଣଙ୍କ ବଦଳରେ ସେ ଯୋଉ ଆସୋସିଏସନ କେସ୍ ଟା କଣ୍ଡକ୍ଟ କରିବ, ଆପଣଙ୍କର କିଛି ଆପତ୍ତି ଅଛି କି? ଆପଣ ଆଉ ରହିବେନି କେସରେ, ଆପଣ ଯୋଉ କେସ୍ ଟା କରିଥିଲେ ଯେହେତୁ କହିଲା ଯେ ଆପଣ ଚାହୁଁନାହାନ୍ତି କରିବା ପାଇଁ, ଆପଣଙ୍କ ବଦଳରେ ଆସୋସିଏସନ କରିବ।
That is the issue, Mr. Mahapatra. He doesn't want to continue by that name. He said, let them file a fresh petition.
That I also suggested.
My lords, once we amend his one automatically, my lords.
How can you amend? How can you amend? The problem is the litigation was instituted by a private individual.
No, my lords, the nomenclature was such, my lords, his name had figured in the beginning.
Oh, sorry, Mr. And he's opposing that. He says, no, not in my place. They can file a fresh petition if they have any cause.
My lords, let me see the affidavit. He had been authorized with the association, my lords, and on that authorization, he had come in and filed his appeal. Today, he doesn't want to appear. That's it.
Where is that authorization?
My lords, that is in the
Have you filed that authorization?
My lords, that additional affidavit, my lords, I request my associate to hand over. We have filed the authorization as well as the revocation.
What is your difficulty in filing a fresh petition? The authorization of the previous appellant, I am talking to you that
yes,
he is refusing to be substituted. He said clearly stated.
He was acting in, my lords, he was acting in representative capacity. He was not acting in his domestic or individual capacity. He was acting in representative capacity on behalf of the association. Once the representation, the authorization.
I think that why from was getting on behalf of the association? He only, in para 2, it has been stated that the secretary of the association authorized him to file the litigation.
Yes,
but it was never filed in the name of this association.
The secretary, my lords, the secretary was implicated as opposite.
We cannot, these strange facts we cannot accept in the proceeding. Because it is simply that you want a substitution by your amendment.
My lords, may I have the additional affidavit, my lords, for a moment? Page 13 and 14.
Yes. He says that
my lords, have a look at page 13 and 14. 14, that authorization was revoked. 13, that was granted in his favor. So we have revoked the authorization. Now the secretary, who is the competent person, because of his ailment, because of that reason, this person was authorized.
I also doubt on that aspect of the matter, that whether the secretary can give authorization when he is not himself appearing, because it has to be taken, the decisions taken by the society's governing body.
Well, secretary, my lord,
no, Mr. Mahapatra stated only provide two persons. One is the president or the secretary, right? Yes, or both can file.
Right, my lords.
Whether that provides the secretary can authorize someone. Who is secretary?
No, my lords, I'll just point out.
Who is secretary to just nominate one to represent this society?
My lords, I'll come to that one. In writ petition, my lords, the association was imputed as opposite party number 5 and the secretary was imputed as opposite party number 6, not in the capacity of secretaries individually. My lords, may see the writ petition, my lords, for a moment.
Okay.
That opposite party number 6 has authorized this person and this person doesn't want to appear. Therefore, the association now wants to amend that and come in place of that person. My lords, there's nothing to hide, my lords. It's absolutely crystal clear.
We are not questioning your right to file the appeal. We are not ever observed that. We said that why don't you file an independent appeal when he is not saying that.
My lords, may see the number of intervention, number of interest stakeholders right now, my lords. Because of the interim order, the association, the interveners, my lords, have made such remarks, which I would like to draw your attention after this exercise is over. They have said that because of your interim order, lordships, on last date, they're saying because of that, there was a delay from last year, this election, for whatever reason, was not happening. They're saying because of the interim order passed by your lordships, there has been a total collapse of the whole machinery. Everything has come to a standstill. They have been casted as persons to the lordships, my lords. This is very unfortunate. The whole exercise, what the interveners who have no locus in this case, they're not parties before the single judge. Now, yes, observation, My lords may see the IAS, my lords, that have been filed.
Yes.
The kind of, if your lordships may have, flag 4, my lords, for a moment. Flag 4, my lords, para 4 at page 3. The process of election has been stalled by the interim order passed by this court. Lordships have it. Flag 4, page 3, para 4. Lordships have it, lordships, I may place.
Which is the interim order you're talking about?
They're referring probably to 31st August interim order, my lords. My lords, I'll recapitulate for a moment. This is a case where the ADM has been asked to finalize the electoral roll. The lordships had observed that the role of the ADM has, in the entire election process, he has absolutely no role whatsoever. The single
What is the purpose? We want this interim order should be vacated.
I don't want, my lords. Lordships had proposed that an independent election officer be appointed. The opposite parties had objected to that. Today, multiple parties are before your lordships. Sort of a proxy litigation is being solved.
So we want a resolution of that. Then
We just pray, my lords, that bereft of any influence, of any external pressure, an independent election officer be appointed so that election can be conducted in an impartial manner. Right now, despite the order of the single judge on 1st August, there are two orders, my lords, the single judge. One of 31st July, 13th July, which is before your lordships now, and one of 1st August. The 13th July, my lords, the single judge had observed that the final electoral roll is to be prepared by the ADM.
Mr. Jena, आपण जो अपील टा एठी दाखल करथिले आपण को सेक्रेटरी देइथिले अनुमति करिया पे एबे आपण करिया पे चाहू नांती आपण को बदल रे सेक्रेटरी निजे कले आपण को तो किछि आपत्ति हबनी ना आपत्ति अछि
Also, we have no objection to file the secretary with application with the amendment also.
I have not given the copy of what is being done. I have already appeared, but no copy has been served on me.
your intervention also.
I have filed an intervention. My intervention has not been allowed. But at this stage, when somebody is trying to withdraw, then a right comes in our favor.
He says he is now agreeable to allow the secretary to come in his place. We allow it without making the compounding further complexity in the matter. This is only the nomenclature, the cost schedule will be changed, nothing else.
No, who will be represented? That we want to know. Who will be represented now?
Secretary is representing.
I have not seen the petition. Let me have a petition to see the petition.
Applied to you. You are also no standard. Because we have not allowed your petition as the
there is only one intervention application or more?
No, Your Lordship, I have also application of intervention.
Yours is still pending or allowed?
Presented by the advisory body whose tenure has been annulled by the single judge. That lawyer was appointed by the advisory body.
Let us dispute a lawyer from this court to hold the election.
That will be the best course of action, my lords. We have no qualm at all if that is done, my lords.
Your Lordship, it will again set the clock back. My only contention is that since
Let the clock move for some time, we stand still and then start functioning again.
In the correct manner, my lords.
But Your Lordship, I have few judgments of the Supreme Court that I want to place before.
That just
No, Lordship.
then after the election process started.
Yes, Your Lordship.
It is a domestic election, it will not apply.
I have the judgment with regards to election of registered societies and also the Supreme Court Bar Association.
All right.
In those three cases, Your Lordship, the Supreme Court has categorically held that once the election process starts,
the court should not
Even by an
interfere.
unauthorized committee. Even
Pardon?
by an unauthorized committee.
Your
You
lordship,
cannot continue beyond certain period of time. You are continuing by forming an advisory committee, and now the said advisory committee or existence is not available in the bylaws. They have appointed some election commission and court cannot interfere. This is your argument.
but your lordship, the advisory committee that was formed, they already, and your lordship, another fact that I want to bring before this lordship is that the appeal that has been preferred, there are other writ applications wherein a similar order has been passed by the learned single judge, your lordship. Those are not also not being assailed under the writ application. So it might
We will not accept what is assailed before us. We'll just look into that. What is the nature of the challenge?
But your lordship, that will lead to a scenario where two conflicting orders of this court is existing at the same time, your lordship. That is my suggestion.
That will examine. We are not passing any order right now.
Because your lordship, I am one of those petitioners who had challenged the non-happening of the election, your lordship.
Yes.
Hence I am before this court for the election to take place.
What do you want under the person who has been appointed by the advisory committee?
Your lordship, my simple submission is that once the electoral roll has been made, the list of candidates has been made, it has been published, it has been publicized that the election.
That time, this is not simple. Any order cannot be that the illegal person, since they have started the process, they will be allowed to continue it. There is nowhere the law. It will show.
Lordship, in the electoral roll, they inducted new members who are not even trouble, lordship.
Okay.
Lordship, they are the committee, advisory committee make an election through zone basis, lordship. Suppose one from this area, one belongs to this area. President must be in Nandapur zone, secretary from Keonjhar zone. This type of election is happening, lordship. In this case, lordship. All are going there beyond the jurisdiction, lordship.
We allow this petition. I think that will not prejudice anyone. Because basically it is the secretary, and now these affidavits will come regarding the locus standi of the secretary, whether he can constitute as a date.
Only the two orders I will place. My lord will kindly see annexed 6 at page 58. The order starts, the lordship will see annexed 6 start from page 58. My lord will kind on to page 61. Opposite party number 6, that is the association was a party.
Yes.
Then this order starts from page 63. The order dated 27/10/2023. And the relevant person is at page 66, internal page 4 of the order.
Yes.
Now, pasting the top paragraph. Though the Land Council for the state raised objection against the maintainability of this writ petition, but in view of the limited nature of grievance of the petitioner who is a member of the association, the opposite party number 4 additional district magistrate Keonjhar shall do well to issue necessary direction to the advisory board of the Keonjhar district drug owners association, that is opposite party number 7, in terms of annexed 5 and 6 for initiating necessary action of the governing body of the Keonjhar district drug association office within a stipulated date. So there was a direction passed by this honorable court to the ADM to issue necessary direction to the advisory board for conducting elections. Accordingly, this order has been given effect to by issuing a notice that is at page 67.
The election schedule you have declared.
Election. That is in compliance of the order passed by this honorable body. And this or direction of the honorable singular has attained finality.
My lord,
That has been challenged by the association. Now,
We will continue tomorrow. Harding Park, let the matter be listed tomorrow. All right, sir.
The interim order, my lords, may continue.
Interim order is passed earlier, shall continue till the next.
My lord, item 2, my lord. Your lordship is asking me to file the agreed order, that is the collector's order in which he has handed over the land to the INCO. And I understand to the affidavit, I am filing this order in lord.
Filing the registry, it will come tomorrow. Today you file it.
My lord, direction was issued to him to file the order of the Tahsildar, by virtue of which this land has been converted from Gochar, not this order.
All right.
Not this order, amendment may be allowed, my
You are
lord.
saying what you are saying.
Let's see what happens.
But I'm saying that the amendment.
My lord, let it come on 25th.
No, not 25th, let it come tomorrow.
There is absolutely no urgency in this matter.
How can you say that it is not urgent?
I
But the amendment in the meanwhile may be allowed.
Constitution division bench on Friday.
Let it come tomorrow. Yes, item 8 will come.
Actually, matters will be taken up. We'll constitute a special bench for hearing these matters, which could not be taken up today. Right.
Plus item 8 plus tomorrow is first item. Item 8 will be called tomorrow first item.
There, my lords, considering the order passed by the Apex Court, fix this matter for expeditious hearing of this case. After registration of the SLD, the state has come up in appeal.
So, it is coming on 15th Friday.
But that amendment may be allowed in the meanwhile because this has no objection. That amendment of cost title may be allowed, I pray, my lords. Since that person.
No, he is not required to come, just instruct who is a. Just
because he is agitated, my lord, for no reason, I.
No, he will not come.
I filed a proposal.
First item number 1 is Mr. Sajjan Jaina, the party, has personally appeared in the proceeding today and stated that he will not anymore represent the petitioner, and accordingly he has filed an affidavit stated that he doesn't want to challenge the process of election in respect of KGTOA for the year 2023. The said affidavit is taken on the record to be considered later. This Sajjan may not appear on future date as his submission has been noted by this court. We just inform that he may not appear also.
My lord, I just have one single point. The copy of the intended amendment petition at least be
Amended is all. My lords,
I can make some objections with regard to that.
All right. That is that tomorrow will be. We have not taken cognizance of the petition.
Item number 15 minutes, interim order was there till today minutes. Item number 15 minutes.
15? All this interim order.
My lord, item 14, your lordship is fixing it to Friday. That is a Friday. So
Friday, because we have
Friday.
constituted bench on Friday.
Yes.
Only because of this leftover matter.
Small prayer, lordship. Also, this item number 1 kindly deleted from YouTube, lordship. Lot of people are sharing this image, making cartoon derivative remarks at their lordship. So
Sorry, we will not. What will be the effect of our order when it is put to a controversial corner? You don't take care of this.
But
Very thick.
but lordship. Item number 13. Yes, sir. It's a part-head matter, virus of the block grant. That your lordship specifically posted today. Let it come on tomorrow, my lord. 15. But little the time is fixed. Well, my lord, so that
Special bench is.
page 2, item 6 to 10. Page 3, item 11 and 12.
My lord, I beg your pardon, my lord. Item number 11, my lord. My lord, item number 11, I pray, my lord, 8 weeks may be given to file the rejoinder, my lord, in this matter, my lord. The public interest litigation matter, my lord.
You can file an affidavit.
Yes, my lord. 8 weeks may be given, my lord. I have to file.
You will file affidavit responding my affidavit, which I have.
Yes, yes, my lord.
Lordship may grant.
Obliged.
Item number 12, my lord. The second sub-item, that's petition number 32208 of 2021. Lordship, Mr. Pitambar Acharya leading in this matter, and there is bereavement in his family. So, Lordship, may I pray for an accommodation? Interim order to continue, my lord. Yes, my lord. Lordship, I have taken the consent of Planet DSG, my lord.
Anything make mention?
Deeply obliged, my lord.
Item number 5, my lord. I pray for one time on behalf of Mr. Bahadur, my lord. Item number 5. Because Mr. Bahadur is suffering from mouth stone, my lord. Any day, Lord, same thing.
Item 2, my lord, may be urgent to tomorrow. My lord. My lord. Yes, no, auntie. My lord. I have.
My lord, item number 13. Item
Page 4, item 13 to 15.
My lord, item number 13 is identical matter, that is WPC 16512 of 2023 at the instance of the same petitioner is posted to day after tomorrow also. It may be tagged with that only. That is my item number 13, WPC 20916 of 2022.
Matter related to preservation and promotion.
That is also
person with disability.
WPC 16512.
Supreme Court has settled the issue.
PIL, that is also, that your lordship has also asked the question to the petitioner who has filed that other writ petition.
Public interest litigation that every person should be the employees or some persons who are working according to education. People are not.
Let to both the matter will tag and counter is not been filed.
No, counter whether it has not been formally admitted or
no notice has been issued. Notice has been issued.
That is maybe tagged with WPC 16512 of 2023. 16512. That date is not with me. Yes,
No, it's okay. But you have urgency or no?
No, there is no urgency in this matter. Along with WPC 1.
Counter may be filed.
Let us see whether let us see whether you have got a case or not. That is to be seen first.
Lordship, I am sorry, I am pardon to mention, Lordship, WPC number 3833.
Mr. Bishwal, kindly wait. Yes. Can you wait for the order? Well. Yes,
I don't think, my lord. I pay, my lord, this matter may can take him today as an event, not this as a last case, my lord. Today.
Lordship, item 10 may kindly be taken up. Lordship, item 10, that is WPC 3833 by 23, Lordship, may kindly be taken up. It is urgent matter because at Mangalajodi, some of the...
11. That is 11. That is already adjourned. That is already adjourned at the instance of the petitioner.
Lordship, I am for the intervener application here. Lordship,
No, intervention has not been allowed.
Lordship, in this case, London Senior Counsel Dr. Adish Agrawal has appeared in this matter, Lordship, on the last dates, Lordship.
Maybe Mr.
Bishwal, could you
matter may taken up, Lordship. What I pray this matter.
Could you please hear? Mr. Bishwal, are you able to hear since you are appearing through a mobile phone? Can you hear us?
Lordship, I am hearing you, Lordship.
Yes, so it was mentioned by the petitioner to be adjourned.
Lordship, a short date may kindly be vacant. What is the 8 weeks time?
Whatever date has been given, you take that date. So it can't be, if you want to earlier mentioning, then you file a memo and serve a copy on the petition. May I call the list? Yes. So submission, item number 1.
May it please this honorable court. Regarding the defects, of 4 defects, we have removed, served the copy and paid the appropriate court fee. After that, we are carrying the legible copies. 3 pages were not legible. I'm carrying by memo. And the final one, certificate of good ground, that whenever the file is returned to the section, I will undertake to do that immediately. We'll do it immediately after. Let's see let's begin. The Appellant University is challenging the order of the learned single judge, wherein a direction has been given to regularize the respondent in the post of sweeper. My 2 main grounds of challenge are: first, there is no sanctioned post of sweeper at the university presently, and secondly, the respondent had not completed 10 years of service as on the date of the judgment of Uma Devi, and in light of the recent Supreme Court case of Delhi University, his case for regularization does not merit consideration. I'll just begin with the facts, then I'll come to the judgment. As the respondent was engaged as a sweeper in the Ravensa College, as it then was, in the year 1997 on a casual basis. We'll find that, my lords, it's an admitted fact in the writ petition also. At para 3, at page 38 of my writ appeal, where I've enclosed the writ petition. Thereafter, my lords, when the respondent was continuing to provide sweeper services on a casual basis, then the principal Ravensa College issued a notice to the employment exchange to sponsor suitable candidates for certain posts, including the post of sweeper. Lordship will find that at page 91 of my writ appeal. We come to the end of the page. In pursuance of the requisition made earlier, you have also sponsored names for the following posts: sweeper, 2 posts. Based on this, my lords, the respondent had applied for pursuant to this notification, and he was called for interview. The notice from the university calling from interview is at page 52 of my writ appeal. But however, after that, no engagement was carried out because of a restraining order which was passed by the Directorate of Higher Education, which is at page 95. It was directed to the principal at that point. Is it? I'll just read out. Office of the Director Higher Education, subject appointment of class 3 and class 4 posts of Ravensa College. I am to request you not to make any appointment to the class 3 and class 4 post in Ravenshaw College till your retirement on 36/99. So after that, no engagement order was passed pursuant to the selection process, and the petition and the respondent was continuing on a daily wage basis in the university. At this moment, in the year 2005, the Ravenshaw College became Ravenshaw University. And pursuant to that, the Department of Higher Education, in concurrence with the Finance Department, published a notification which is at page 102 of my writ appeal, where they sanctioned the non-teaching posts in the university as well as abolishing the earlier all the posts. I'll read out the relevant portion here at page 102. It's from Government of Orissa, Department of Higher Education. It's issued to Accountant General, Orissa. The subject is creation of non-teaching posts at Ravenshaw University, Cuttack. I am directed to convey the approval of the governor towards creation of the following non-teaching posts in Ravenshaw University in lieu of abolition of non-teaching posts, non-teaching in erstwhile Ravenshaw Autonomous College, Cuttack. You see the list of posts here. Sweeper is not a post, and it was earlier in the Ravenshaw College, but it was abolished by this notification by the Higher Education Department in concurrence with the Finance Department. Similarly, my lords, turn the page over at page 104. Again, some further non-teaching posts were created in 30/10/2018. Subject again, my lords, creation, abolition of non-teaching posts in Ravenshaw University. Again, my lords, the list of posts does not include a post of sweeper. At this moment, the respondent had filed the writ petition initially for consideration of his representation for regularization. The representation was considered and rejected. That is at page 51 of my writ appeal. Page 50 of my writ appeal, pardon my lords. On the sole ground that there are no sanctioned posts of sweeper in the university since 2009. The respondent challenged this order by way of the second writ petition, the judgment of which is now in the said judgment, my lords. The learned single judge has directed for regularization against the post of sweeper, and that is my main grievance, my lords, because there is presently no sanctioned post of sweeper since 2009, and therefore the direction amounts to creation of a sanctioned post, which is not permissible, not within also the power of the university to do. So that is my main ground of stand. The second ground will be, my lords, that in light of the recent decision.
Yes, my lord. I am referring that. I am not sir copy, my lord. I am not issue. Yes, my lord. Yes, my lord. Yes, my lord. Yes, well, no, short time and granted. Next week, I will file a counter, my lord. Yes, my lord. Yes, my lord. My lord. Yes, my lord. No, my lord. Whatever submitted my learned brother, totally false, my lord. I am yes, my lord, totally false, my lord. It is a hide and seek doing before the honorable court, my lord. My lord, yes, I am engaged in. I am continuing regular post, my lord. In 1999, when their college sweeper post, my lord.
Now this video shows the restructuring of the university.
My lord.
No, I am in continuing, my lord.
College does exist.
Yes, I am exist since 99 to till that I am.
College exists.
No, 2005 this college is bifurcated university.
It shows that the university or the higher education department restructured the pattern of the stuff.
My lord, in this, my lord, sorry, my lord, in 1999, a college invited a notification. In notification, 16 posters there. Out of 16, my lord, out of 16,
Yes, my lord. I am. In my rejoinder, my lord, I'll see in my rejoinder, 8, my lord. Annex of 10, my lord. I'm.
Mr. Pal,
Yes, my lord.
instead of going for that, whatever he's saying is totally false, don't make that kind of a submission. You answer the specific query, the fact.
Yes.
That against which post, when you were appointed, what was the post, how many posts are there, to show that.
Yes, my lord. Annex of 10, my lord, and in my rejoinder.
It was not part of the writ petition.
Yes, part of the writ petition.
And how do you say it is under rejoinder?
When I rejoinder, I have annexed the annexer in rejoinder, my lord. I am not that annexer.
Where is your averment in the writ petition that you were recruited against which post?
I am recruited, my lord.
You find out from your writ petition, then you submit. Prepare yourself.
My lord.
Don't say like that. Whatever he is saying is totally false.
My lord. Brother, my lord. To you rejoinder. Yes. 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 This is the order I think you are referring to. My lord, kindly see sir, annexer 10. My lord, in 2877 26. Rejoinder. Post of Mavi, 2 posts. No, sweeper. I am in sweeper. Sweeper, 2 posts. I am apply and interview 2 posts. In total post is 16. My lord, out of 16, already every post is filled up by the college. The age at that time when the ban order is imposed, thereafter they file a case. Honorable court direct to the college, and the college they are regularized the post. Age I am at that time I am not file a case. That's why I am not regularized. But I am continuing this post since 1992 till date, my lord.
102, my lords.
102 in the writ petition.
102 in the writ petition. In the writ appeal, my lords. I have included.
So referring to the writ petition that, so it would be better if you refer to the writ petition.
In the writ petition, it's an additional affidavit which we have filed on. My lords, we do not have the additional affidavit. It just follows immediately after his rejoinder, my lords. Page 6 of my additional affidavit. I've enclosed that as part of my writ appeal, all the pleadings, my lord.
Everything is regularized. Attendance? No. Group D or Group C post? Group D post. Group D post.
Well, it's all sanctioned by the higher education department.
So perhaps he is unable to articulate that. Whether the existing posts were
attendant posts used also be there in the revenue
posts that those were existing, they have been abolished.
My lords.
Say so.
At the beginning, my lords, at the top, I am directed to convey the approval of the governor towards creation of the following non-teaching posts in Ravenshaw University in lieu of abolition of non-teaching in erstwhile Ravenshaw Autonomous College.
No, it talks about the new.
Lieu, my lords, in substitution of, like the old posts were abolished.
Oh, the attendant post is there.
It's there, Mel's. May find it at also page.
Where any person they just put up it to be the service and you have similarly situated persons there all regularized by virtue of the order of the court. Court. Objection number when you were this suddenly finding out one person taking out of this stock and denying the opportunity of regularization, and you find the post of attendance is there for the 6 posts have been created.
Whereas attendance was a post also under Ravenshaw College. May find that at 91. Yes. Sweeper post was there. Attendant post is also an independent post, my lords.
I understand, but it can, one thing is in the amendment could be, if it is a board, the group lead goes.
Malas will have to see the qualifications in that case, whether he meets the qualification.
You are yourself saying no, the recruitment group shall be made.
Malas, I will check, I'll take instruction on that, Malas. Malas. Malas, also take note that presently there is no post of SIP. Yes. In fact, Malas, it's a state policy also not to regularize super. Even in 2013, when the state came out of Group C, and
just situation where service from this person for last almost 25 years.
Malas. Malas. Let the petitioner respondent also supply his qualification. Malas, we'll examine that in
representation. I have already shown
whether he meets the qualification for the attendant posting.
If any other group D post is there, and if somebody who were continuing on the date of this order,
my lord,
they have retired, then what happened to those posts?
Malas, those after
because he doesn't abolish the existing posts. That I wanted to ask you actually.
Malas, there is a noting there, my lord said.
I got that.
Yes.
Please appreciate a situation where the persons who are working.
My lords.
Is it your contention that those persons who are working, their posts have been abolished?
Malas may find that answer. Is a paragraph here, Malas, at 4, just
page 102.
Page 102.
No, I mean,
I think
I think you want to take the instruction. Because on 6/4/2009, then your contention is on 6/4/2009,
my lords,
the persons who are working in Revenue College have been abolished.
My lords, it's
accepted, then
the notification takes care of it, my lords.
No. It cannot be. It cannot be. Then where the posts have gone, where the persons have gone rather.
My lords,
on 6/4/2000, rather 5/4/2009, who were working in Revenue College, what happened to them?
My lords, it's mentioned here in the notification.
No, it's not mentioned.
I'll just read out the paragraph, my lords.
No, please find out which is the paragraph.
It's mentioned, for instance, in the
199 non-teaching posts of the past 12 Revenue Autonomous Colleges have been abolished under this. Every day, this department order number so and so, so and so. Find that. So it is prospective. So what happened to the earlier posts, the persons who are working?
In the column above, in the last, it's mentioned here. Does this post are created in?
No, Mr. Mahapatra, your point is well taken.
My lords.
So whatever was there, but the persons who were working then on 6/4/2009, what happened to them?
Just written here. They will be adjusted against those who have qualifications. They will be adjusted against this post. Those who do not have qualifications.
How can that be? Regular person working regularly will be certainly thrown out of job.
No, they're not thrown out of job. It's mentioned here. I'll just read out the relevant portion.
Suppose a person already regular establishment, he doesn't have the qualification. You discover now on 6/4/2009. Do you mean to say that he'll be thrown out of job?
No, I'm not saying that, my lord. So I'll just read out
that. Indirectly, you are saying that.
No, I'll just read that portion out, my lords. I'll just read it out. The post may be filled up from among the existing staff or having requisite qualifications subject to exercise the option to continue in the Revenue University in order to avoid future litigation. The other employees in position having no requisite qualification may be adjusted against vacancies in other government colleges. So this takes care of that.
Oh, you are not getting, sir. So sweeper working on 6/4/2009, what happened to him? That is the short question.
My lords.
So you are finding out whoever is working as a laboratory attendant or something, he doesn't have a qualification. And also that logic is also strange because a person who was working in Revenue College, the premier college, he's underqualified and is qualified to work in another government college.
My lords.
You see, even Revenue College is prior to Utkal University. No university was there.
My lords. I will take.
You please check up that.
I'll take instruction on what happened to the people who are continuing in regular post. But the notification seems to suggest that they were adjusted based on the qualification against this 199 post. My lords. I will take for instruction.
That amounts to discrimination.
My lord,
But suddenly by a notification, you change their qualification and they would disentitle them for continuance. If that has happened, what you are saying.
my lord, I will take instructions on that, my lord. My lord, may call it next week because it's an old matter, so it will take some time. Monday also will do, my lord.
My lord, copy, my lord, one copy.
Yes, and immediately, sir.
My lord, humble prayer, my lord. One, OJC number 7544, those employee who are interview and file a case and get a job, my lord. Judgment only, my lord. Honorable court pass order, my lord, read out.
Mr. Pal, you produce their judgment for perusal of the court. That my lord is asking you. I just apply a copy to Mr. Mahapatra also, or he might be having it that also.
Yes, yes.
Item number 3.
I may please, Lordship. My lord, to kindly say, annexure one of the writ petitions. At page 18, annexure 1 at page 18, there are two plots, 1127 and 1129. And those two plots are reserved for the UP school of Orakakuda village. But the opposite party number 3, unauthorizedly and without any permission, occupied those two plots and now raising construction for a market complex. That was objected by the villagers and the guardians of the students of the school. And there was another date in which the construction was stayed by the Supreme Court. But due to the sudden death of the petitioner, husband of the petitioner and also the mother-in-law, it was dismissed for non-prosecution.
Which one?
The previous one, my lord.
Yes.
Then now, after dismissal of that petition, now the Sarpanch is again raising construction for the market complex. Forcibly occupying the playgrounds of the school without changing the nature and character and without any prior permission of the company.
As it appears from page 18, that both these plots were reserved for the school playground. Not private, but it's a government project. Page 20, annexure 2. Yes, of the Panchayat.
Panchayat project, not a government project.
Yes, Panchayat. And you will see that page 21, it was the report for the year 2017-18.
There is a representation filed by Mr. Raut to the collector. No action has been taken according to his petitioner. Collector should personally survey the area and without affecting the school playground, the construction may go. Otherwise, it will not be, should not be allowed. Huh? That observation. Okay. Mr. Raut. Heard Mr. Niranjan Raut and counsel appearing for the petitioner. Also heard Mr. P.K. Mudali, learned additional government advocate. By means of this public interest litigation, the petitioner has urged this court to direct the opposite parties number 1 and 2 to take all remedial steps for restraining the opposite party number 3 and 4 from their illegal encroachment of the government land and construction of a market complex over the plot numbers 1127 and 1129 of Khata number 345 of Moja Arakakuda under Patkura police station, Chandrupala. So the grievance of the petitioner is that that the earlier also public interest litigation filed, but the said petition was dismissed for non-prosecution. Taking advantage of this, the said order, the opposite parties number 3 and 4 have again started constructing the market complex on the government land as stated. Mr. P.K. Muduli, Learned Counsel on scrutiny of the records has stated that the market complex is a project of the Panchayat under the aegis of the government of Orissa. Therefore, it is not an individual, it is not an individual project of opposite party number 3 and 4. So be that as it may, petitioner had filed one representation to the collector, Kendrapara, Tahsildar, Goradapur, Kendrapara, Block Development Officer, Kendrapara, and Sarapanch, Madhusudan Gram Panchayat, Kendrapara. Madhu Shashan, not Sudan.
Madhu Shashan, madam.
Madhu Shashan Gram Panchayat, Kendrapara, urging to stop the said construction. Stop. But no action has been taken on the said representation, though the said representation was filed on 21st February 2023. Mr. Raut, Learned Counsel has submitted that if the construction is allowed, the school's playground will be truncated and its utility will be reduced. Stop. Having appreciated the submission made with the Learned Counsel for the petitioner and the state, we direct the opposite party number 1 and 2 to initiate the survey of the land to ascertain whether the construction is coming on the school ground. Stop. For purpose of construction of the market, as far as practicable, the school ground shall not be used. Stop. In view of the said observation, appropriate action shall be taken by the opposite parties number 1 and 2. Stop. We give liberty to the opposite party number 1 and 2 for keeping the school, the size of the school ground. There can be an adjustment by adding and deducting some part of the land, but the utility will be the school ground shall under no circumstances be reduced. In terms of the above, this petition stands disposed of. A copy of this order is served on Mr. Muduri, additional government advocate, 4th. All right.
Item 4, roll it.
May it please your lordships, my lords, I'm appearing on behalf of Mr. Achari. This is a PIL matter and it has been filed by the secretary of the Panchamukhi Hanuman Temple, Hanuman Mandir in Badrak municipality. Now, my lords, in this matter,
think the defect number 6 is there. Copy has not been served.
I'm serving a copy, if your lordship, I'm serving a copy to the Learned Counsel, my learned chief. My lords, in this PIL, basically the Panchamukhi Hanuman Temple, my lord, that is being surrounded by the minority community. Now, what has happened is that the waste of the animals that is being disposed of near the temple premises, which is not only violating the sanctity of the temple premises, but that is also hurting the religious sentiments of the people of the community that is visiting the temple, and a lot of religious functions are also held in that temple. So, my lords, under Annexure 1,
making so many allegations against persons who are not in the parties here. No, my lords, please appreciate that you may have a cause against the OP number 3 municipality. And
Yes, my
also
lords.
that you have not made him proper party, you have made the executive officer a party. You have to make the municipality a party represented through so and so, so and so.
Yes, my lords.
So don't start giving a speech that so and so is dumping a animal, this carcass or something or animal. Please don't do that.
My apologies, my lords.
So it's not a question of apology. You have to be particular. You as officer of the court, you are a lawyer.
Yes, my lords.
You have to be careful about your pleadings.
Yes, my lords. My lords, the representations have been made before the
Mr.
collector.
Muduli, this a lot of people visit this temple. If this is the situation, you take instruction, you're fixing the matter on Monday, and I'll go to remove it some other place, okay? And it can be removed, you can dispose of the writ petition without any order also. Only this, the garbage container is the issue, entrance of this mandir that has been placed.
Yes, my lords.
It's a small issue. Right? By means of this public interest litigation, petitioner has sought for removal of the waste disposal containers and garbage from the entrance of Sri Panchamukhi Hanuman Temple, Bhadrak. We request Mr. P.K. Muduli, an additional government advocate, to take instruction from the collector Bhadrak and from Bhadrak municipality through the collector whether the garbage, the waste, what do you have told it? Waste disposal container. Waste disposal container and the garbage can be removed from the entrance of the said Hanuman temple. Stop. Prima facie, we are of the view, if the situation is as such as has been stated in the petition, it requires immediate attention, as a lot of devotees are visiting the temple every day. Let the matter be listed on, give the date on Monday. Meanwhile, Mr. Muduli shall obtain the instruction. What is your good name?
Shubhankar Das.
Mr. Shubhankar Das, counsel appears on instruction of Mr. Ramdas Achari.
Yes, my lords.
Counsel for the petition.
Gratefully, your lordships.
Item number 6.
6, I pray for Passover. Kuntia is on his legs in another court.
All right. Passover, no, just fix it Monday. Next. Any urgency in the matter?
Yes. I am appealing for the respondent.
Tomorrow. I'll list tomorrow.
Right.
As request has been made for Mr. N.K. Kuntial and counsel appearing to the appellant. Mr. Ranjit Mohantil and counsel request for the sole respondent. All right, tomorrow we'll take up.
Okay. Item number 7.
Item number 7, my lord. IA for combination of delay of 6 days. Filing of the writ appeal.
$14 days.
My lord.
So you have to take notice because there is no standing counsel of the TPCODL now.
But I'll take notice.
You'll take notice, okay. I think you will not oppose also the 14 days delay only.
Maybe
instruction required.
Instruction based copy is not there.
Copy, right?
I'll take.
All right, just I 2434 of 2023. heard Mr. Binayak Prasad Mohanty and counsel appearing for the applicant. This is an application under Section 5 of the Limitation Act. 14 days delay, Mr. Marana. I think it can be. This is an application under Section 5 of the Limitation Act for condoning the delay of 14 days in filing the appeal under section, filing the intercourt appeal from the order dated 23rd March 2023, delivered by the learned single judge in WPC number 3546 of 2013 for condoning the delay. Issue notice since Mr. Maharana, your LK Maharana, Learned Counsel, appears notice for the opposite parties, so respondents, opposite parties. No formal notice is called for. Mr. Maharana, however, has stated that the opposite parties will not oppose the prayer for condonation of delay. So accordingly, we have also perused the causes assigned in this petition and taken note of the concession given by Mr. Maharana and counsel for the opposite parties. We should have been dismissed already. Huh? Already. We condone the delay of the hospital. The result is that he was cancelled out. Just now the come on the merit of the appeal, my lord. What is the infirmity in the judgment?
My lord, the boy of 12 years died by electrocution.
Can it be decided in a writ proceeding? Can it be tell us? It is a fatal accident case.
My lord.
There is the Principal Act provides there should be a suit under section 1A of the Fatal Accident Act 1940. Why the writ petition will be entertained? Because they will plead that we are not responsible. So you have to leave the evidence. And the writ proceeding cannot record your evidence. Affidavit versus affidavit always doesn't support us. So we grant liberty, and we also observed while dismissing your appeal that the time you have pursued in this High Court should be discounted in section 14 of the Limitation Act, right?
My lord.
Huh?
It is ex gratia.
Ex gratia, if under any scheme government grants you, that they will give you just claim it. But ex gratia is always on the condition that you will not file any suit. If that condition is not there, you can accept that ex gratia. Otherwise, you can also take this plea in your suit for interim relief.
My lord.
Only on the suit it can happen. I think we have made our mind clear. Will not be interfered. Only that we just observe categorically the time he has wasted in pursuing these proceedings shall be discounted in filing the suit.
My lord.
Right?
In the case
You applied for ex gratia, you received or you have not received? You could not answer.
I pay before the electric authority, but they did not pay any ex gratia.
Maybe they are disputing the death by electrocution. That may be the case. In that case, the ex gratia will not be paid. Because the some observation is available in the learned single judge order, we say this will not influence the proceeding in the suit. Right? You just
in Madras High Court decision, there is a in read jurisdiction. But Mr. Mahanti, actually,
I can show a Manipur High Court decision that the writ petition doesn't lie. Which one will rely? Madras or
Odisha High Court decision also.
In fact, our own
Interpretation versus Sukamani,
you see that this
Odisha High Court, there is a difference of opinion. Honorable judge, they refer to a larger bench and then they said that yes, it can be granted. Then Supreme Court said since because one has to give a finding that they were negligent.
I think it's a safe recourse because otherwise you'll can avail of the more forums if anything happens to you. Now, if you decide you have to go to the Supreme Court, we understand this coming from the poor family. That is just immediately go to this under this special act, you go and file the suit. And the problems that might happen, we are trying to give some observations for you.
Suit may be decided within a stipulated time direction.
That will, you have not filed this. I will file. You file it, but without filing a suit is not there. We say that dispose it within such and such date. People will laugh at us. So we are observing you that these things. Heard Mr. Such and such. Just take the earlier names, employees. Challenge the order dated 23 March 2023 was with the learned single judge in WPC number such and such earlier description. This intercourt appeal has been filed. Stop. Learned single judge by the order dated 23rd March 2023 has observed that the dispute is predicted in the writ petition cannot be adjudicated under a proceeding or adjudicated in the proceeding under Article 226 of the Constitution of India. Stop. Having observed that, and a single judge has further observed that the petitioner may avail the remedy in common law forum, if it is still available to him. Stop. The case of the appellant is that the death of the child took place on 19/11/2008 for electrocution. The case of the respondent was before the learned single judge was that 11 kV conductor was drawn 25 years before by the erstwhile Orissa State Electricity Board over the said building. The 25 years stop. It is also the case of the respondents that the building was constructed later on. After the construction of the building, repeated representation was made to the distribution company to shift the overhead conductor, but that was not done. The respondents also took a position that there had been no negligence on their part. In the face of such disputed facts, the impugned order has been passed. We do not find any infirmity in the order. However, we grant the petitioner liberty to approach the civil court of the competent jurisdiction by filing a suit under Section 1A of the Federal Excellence Act 1940, following the due process. So, we also further observe that the time the appellant has lost by approaching this court by filing the writ petition being WPC number 354/6/2013 and or any other previous proceeding, and also the present appeal being WA 948 of 2023 shall be discounted under Section 14 of the Limitation Act. Stop. That apart, it has been stated that no ex gratia payment has been made under the scheme by the respondents. So, the petitioner may also file a representation to the respondents without prejudice is cost that may he project in the suit as contemplated for payment of the ex gratia. If such representation is filed, the respondent shall consider such representation with human touch. Stop. Representation may be filed within 15 days from today, and the respondent shall take a decision over the said representation within next 30 days thereafter. Stop. Having observed this, these appeal stands disposed of. Before parting with the records, we would like to note that any observation made by us or the learned single judge will not affect the adjudication of this suit.
Item number 8.
Item number 8, my lord, I'm appearing for the petitioner. I pray for only additional 2 weeks time to file rejoinder because I was down with dengue. For that reason, I could not prepare the rejoinder.
You are Mr. Roy?
Yes, Roy, my lord.
Mr. S. Roy and counsel appearing for the petitioner. Urges for a short accommodation, we stand allowed. Let the matter be listed on 9th of October 2023. Meanwhile, the petitioner may file the response affidavit. Stop, Mr. Okay.
There are two counters.
Mr. Mohanty, are you appearing in this matter?
Next matter.
Mr. P.K. Mudalil, an additional government advocate, appears for the state opposite parties. All right.
And OP number 4 also appearing by private.
Who is appearing for OP number 4?
My senior is arguing. On behalf of Mr. P.K. Naik, my senior is arguing on another matter at court number 12.
All right, let us come. We have just adjourned the matter. Okay.
Item 9.
Publishment.
May I please your lordship? Lordship, I am in virtual.
Yes.
My lords, 9, your lordship directed to file an affidavit. File, my lords, the affidavit and serve the copy. The proposal has been, my lords, changed, my lords, that acquisition of the lands in the villages of the petitioner, that has been changed to somewhere else. So, it petition has become infructuous, my lords.
Lordship to submit.
My lords.
Lordship to submit that the
affidavit.
Yes, ma'am.
I've served the copy.
Lordship, to only quote one thing, my lord. The administrative approval is annexer 10 and 11 to the writ application, which was challenged in the writ. Now, in view of this affidavit, those two annexers, 10 and 11, is to go. That much only to be observed. With affidavit,
this has become really ineffectual because they have changed it.
But that administrative approval in respect to these two villages still not
that. We can observe that.
Yes, that much.
Lordship, only thing, my lord, the proposal has not been dropped, but it will be shifted to somewhere else, not in the villages of the petitioner.
No. My submission.
I will record, Mr. Mappa.
There is no such prayer for proceeding on item 9 and 10.
10 and 11. 10 and 11.
There is no such prayer.
All right. Where have you stated so?
10. My lords, para 8 and 9 of the affidavit.
Mohanty, kindly take additional affidavit.
My lord.
In support of counter affidavit. What is the cause? I mean,
page 366, my lord. Page 366.
366, my lords. Running page.
Para 8 and 9, your lordship kindly see. My friend was testing para 9.
You are referring to page 300?
66, my lord.
66.
Internal page 6, my lords, of the additional affidavit.
Oh, there is 2 addition. All right.
That is affidavit. It has been
so many additional affidavits.
That is
16 days.
okay.
file, Mr. Mohanty?
Filed on, my lords, 23 August, my lords. 3rd August, recently.
My lord's direction was 17th of August, and I think the opposite party filed the affidavit on 20th. Only thing, my lord, this last page is 360. 2 administrative approvals that they accorded. On that basis, the 2 villages were covered. Now they are shifting the site to another place. So therefore, these 2 villages, which is now made free, so that administrative approval which is accorded, that is to go. That was my only submission. These 2, that much.
Do you have a copy of this on the affidavit?
Hello, sir.
Already there, physical records.
Lordship, to turn to page 3 of the affidavit, last para. Present affidavit. Page 3, last para. The government and Steel and Mines Department have been pleased to accord administrative approval for acquisition of private land measuring 96 acres, 943.
Mr. Mahapatra, he did not challenge the administrative approval. That's the problem. In fact, administrative approval, as far as concerned, it remains, but the acquisition has been changed. So, kindly find in your prayer, you have not challenged. In fact, it is not required also. You don't intend to challenge administrative approval because you are only concerned with the acquisition.
2 villages where the land is
by questioning those approvals, it may have other ramifications. So why
Lots of your kind glance in the annexer. Only village. Name village.
No, Milord, he has no locus now at all.
Exactly.
Yes, Milord, kindly see, this is not a acquisition at all now. This was in a preliminary stage.
Section 4 is a preliminary stage. There is no question of 11. 11 will come. Thereafter, my lord, he has a right to objection in 15. Then 19 declaration. Then he has a right.
So that is
He doesn't have any right here, my lord.
that is a question to be taken if it is hard on merit. So since now
No, this is not. It is now. It becomes academic.
it has become academic, so therefore
Yes, so where is the full notification regarding these two villages? They have withdrawn it.
Hearing has not been.
After withdrawal of that, Mr. Mahapatra is muted, I think. So Mahapatra, can you unmute?
Heard Mr. Manoj Mahapatra, and its senior counsel. Mr. S. Mohanty, and its senior counsel. Mr. Acharya.
Mr. Acharya, I Acharya.
I Acharya.
For OP 10.
Counsel for the opposite party number 10. And Mr. P.K. Mudoli, an additional government
11.
appearing for the opposite party number 11, and Mr.
11.
Pardon, my lord.
Mohanty, and counsel appears for the opposite party number 8.
Pardon, my lord. I am appearing behalf of Subir Pale, senior counsel, for OP number 3, 4, and 7.
For whom? What is your good name?
Satyajit Das.
No, what is your good name?
Satyajit Das.
Satyajit Das. Mr. Satyajit Das, and counsel. Appears for opposite parties number
3, 4, and 7.
3, 4, and 7 on instruction of Mr. Subir Palit, and its senior counsel. So PW opposite party number 8, ITCO, from our Orissa Industrial Infrastructural Development Corporation, ITCO, has filed one affidavit on 23rd August 2023. The said affidavit it is stated by ITCO that it.
So Pranab Mohanty, you refer to which paragraph?
Para 8 and 9. 8 and 9. Your lordship may take 8 and 9.
Starting from para 7, it's
Acquisition of land for the user agency.
para 8 and 9 together. But I want it for me.
The land is proposed to be acquired by annexation 9 and 10 and 11.
No, 10 and 11 are approvals. So he has not annexed the notice.
Yes, my lord, it is there. I must be on
meeting is at annexure A by 8.
I refer to that.
Can you give Mr. Mohanty, can you give me a copy of the notice?
That copy of notice, my lord.
My lord, I refer to para 6 of my prayer. Para 6 of my prayer.
No.
Not admitted.
Your lordship, kindly turn to page 30 of the writ petition annexure 2. This is a Gram Sabha notice under section 41.3, not rule 41.3.
Prayer 6.
And this 41.3 is the preliminary stage prior to section 11.
Is reflected.
The new act speaks.
All right. Is reflected in the general notice under number 45 dated 5th January 2021, annexure 2 to the writ petition. So for that purpose, the administrative approvals were given by the communication dated 18/10/2019, 18/10/2019, annexure 10.
In 11.
And Annexure 11, the same date, both the latest.
Yes, yes.
Yes. Communications, dated such and such, annexure 10 and 11. The petitioner, by means of this petition, asks this court to declare the said proposed accusation as illegal so he has also asked for quashing the communications dated 18/10/2019, annexure 10 and 11 of the writ petition. Stop. From the affidavit filed by the opposite party number 8, it appears that ITCO has abandoned the said proposal to acquire land as reflected in the notice
1810.
dated 5th January 2021, annexure 2. The said affidavit dated 23rd August 2023, ITCO has averred as follows, paragraph 8 and 9. Stop. 66. Mr. P. Mohantil and counsel appearing with opposite party number 8 has submitted that for all purposes this writ petition has become infractuous. So, in view of the said affidavit filed by the opposite party number 8, the communication dated 18/10/2019, annexure 10 and 11, which has become inoperative and as such no specific order is required to be passed. In terms of the above, this petition is disposed of.
Item number 10.
May I please your lordship? Here, my lord, also kindly have a glance in the order dated 9/3/2023, wherein I have served the extra copy to the Lord State Council as well as the private respondent, my lord. So, your reply has been filed. And one more thing is, my lord, in this case, the Lord Senior Counsel, Mr. S.P. Mishra, has been engaged. In the order sheet, the name has been reflected, but in the cause list, the name has not been reflected.
The name may not be reflected also. It is not meant to be.
Difficulty, my lord, I have to communicate him because it will be taken up any other table. If they are filing any reply, my lord.
Read the private reply is not required. I am from the private respondent.
Yeah.
The stay order is operating against me, my lord. If I learn train that trace for time, that means come next week. I request that trace admission matter that will be listed, that will be disposed of.
Yes. Reflecting the name of Mr. Mishra in the cause list, my lord.
All right. You are Mr. Asori.
Arachari.
Lord Counsel appealing for the appellant. Also heard Mr. T.K. Moduli.
No, my lord, I am here.
Oh, Mr. M.K. Khuntiya. And counsel appearing for the respondents number 1, 2, and 3. And your good name, sir?
Jatindra Kumar Mahapatra.
And Mr. J.K. Mahapatra, learned counsel for the opposite party number 4. Yes. Mr. Mahapatra, learned counsel has submitted that by the order dated no interim order is there?
Yes, my lord.
Yes, ma'am, there is.
IA 2735 of 22. Till the next date of hearing, there shall be stay of informed order to put.
Right.
Order dated 9/3.
By the order dated 9/3/2023 and delivered in I number 2735 of 2022. An interim order is operating against the judgment of the learned single judge. As a result, the opposite party number 4 cannot proceed for this implementation of the said judgment dated. Said order dated 13/7/2022, passed in WPC OAC number 950 of 2013. Let the matter be listed on the next Tuesday.
Next Tuesday.
Then Wednesday, 21st it will come. 21st September 2023. There shall be an attempt to hear the matter finally at admission stage. At the admission stage, I will be an attempt. Directed to reflect the name of Mr. S.P. Mr. and Senior Counsel of the Council for the applicant.
Item 14.
That's the interim order.
Interim order discussed party.
Item 12 adjourned. Adjourned. 11th October.
11 October.
11th October.
Lordship, may reflect my name, may be reflect in the cause list. This was the
You were not there when you passed the order. Oh, that cause list, your name is not coming.
Yes, yes.
CGC name.
One CGC name is there, it's not taking, that's why it's largest.
Take them.
Lordship, item 12, the first item is the monthly estimate. Connected item when it comes to the second time, the interim order there in the first item, Lordship, that will continue.
Just chill with the answer.
Item 14.
Notice has been issued in this case. Body is appearing. Meantime, this case may be listed along with WA number 368 of 2023, man. Because the same judgment has been challenged by CDA.
2018.
The case WA number 368 of 2023.
You are Mr.
T. Pradhan.
At the request of Mr. T. Pradhan, let the matter be listed on 9th of October 2023, along with WA 368 of 2023. Mr. M. K. Khuntiya and an additional comment advocate is appeared for such response. He's only for okay one.
I am for only copy one. Separate now.
Same counsel appears for the respondent number 1. Despite due notice, none appears for the remaining respondents.
Yes. The tracking report is so that item is delivered. Tracking.
That is what we have said. Despite due notice from this court, they are not appearing.
Yes.
Item number 15.
My lordship, in this case, your lordship will kindly come to the noting.
Sir, who will give respect?
No, I am not saying anything to your prejudice. Nothing to your prejudice. consolidated cost title is supposed to be filed by them. So I was only requesting my learned senior since he is in the adjournment mode to do. So,
First of all, it is 325, number one. Number two, Mr. Sarada Sodangi, who actually briefed me at the briefing council, he is suffering from last 3 days fever. I asked him to get tested for dengue. But now in CDA, dengue is rampant, my lord.
Yes.
So I asked him that.
No, I'm not on many. I'm not on many. It's something like that. Only that day, actually, I've observed that the consolidated will be filed before the next date. That's all.
21st.
Whenever it was lot 21st.
21st. I think my senior
Go to the October.
because of 2009, my senior has given a consent that it may be fixed to 21st. I humbly pray to fix it 21st so that matter can be
October. Subject to his
21st
of this week.
Because the lot of matters are fixed on 25th.
Right.
We go to the October, 9th or 11th of October, choice is yours.
Your Lordship, please, my lord, any day.
9th or 11th of October.
Your Lordship may kindly argue it in 26th in September. I pray my lord because it's a old matter 2019 and today 1% that today is 11th day. So in the meantime, the 5% died, my lord.
What my learned friend is trying to say is that petitioners are progressively passing away workmen. So I leave it to a lordship, my lords, whatever your lordships.
5th of October. 5th of October. Grateful. The matter is listed on 5th of October 2023. Grateful. In the meanwhile, the petitioner shall file the consolidated cost title. After serving the copy, the learned counsel appearing for the opposite parties, Mr. SP Mishra and counsel appears for the petitioners. Mr. Muduli was there. No, Mr. M.K. Kuntial and counsel appears for the state opposite parties. And Mr. Das.
I am on behalf of Mr. P.K. Das.
All right.
For the opinion number 2 in past case and connected in the for the
So in other
petition.
cases, this Mr. Palit, you are appearing for on which case?
4 to 50, my lord.
4 to 50, CBM.
4 to 15 in the first case, man.
4 to 15.
In the first combined order, give the councils name. You take the names of the council. Real combined order will reflect the names of the council. Just collect the names of the council. Yes. Over.
Great.
Oblige.
For hearing. Item 1.
You first over asking to complete within 15 minutes.
I'll try to complete within that.
Okay.
Yesterday, I was placing people 6, page 114. What extent he has deposed, I don't want to take more time. So let's say kindly see only 114, page 114. The father of the victim as well as informant. I'm not, though in the first paragraph he said there was a demand prior to marriage,
in para 2, you'll also kindly see, 4 days after the marriage, the deceased and her father-in-law demanded further dowry from me over telephone. My lord got it? Yes. Only my lord, he has named the one of the accused is father-in-law. And he has stated, my lord, over telephone he demanded. Well, also can subsequently also kindly see next page. Repeatedly we are getting such phone calls. The deceased also complained before me her apprehension of torture. So there was no torture at the time of telephone call. My lord, kindly bear with me, my lord. His specific case is that there was apprehension of torture. At the time of telephone call, there was no torture at all. So far as PW6 is concerned. Why I am placing PW6, I am giving much importance to PW6, but he is the complainant himself and he is the father of the deceased, the vital witness. If your lordship will see the para 3 of the his evidence, he has stated he reached at Jharsuguda at 4 p.m. For the first time he reached at Jharsuguda at 4 p.m. You will also kindly see in his subsequently what he has stated that in para 5. He reached at Jharsuguda at 2 to 2:30 p.m. in para 5. In PW20, who accompanied PW6, he has stated we reached at Jharsuguda at 1 p.m. Even though they came to Jharsuguda at 1 p.m., lodging of FIR is 11:30 p.m. Though they are very much present and they have witnessed to the inquest, in their presence everything has been done. They waited after completion of PM, they lodged an FIR, and what he has stated, but he has exaggerated his statement. I went to the police station at 5:30 p.m. I lodged the written report. Police did not register FIR. Advised me to come at later after completion of postmortem. Thereafter 11:30 we came and registered the FIR. You also can see I am indicating the vital portion of the evidence of PW6. That my lord will find para 10 of his cross-examination at page 119. My lord, he has stated for the first time I went to police station to lodge the FIR at 11:30 p.m. Though prior to that, he has stated in his evidence that I had gone to the police station at 5:30 and lodged the written report. They advised me to come after completion of PM. But in his cross-examination para 10, he has stated for the first time I went to PS and lodged the FIR at 11:30 p.m. Even if we are considering the entire scenario, but my respectful submission before lordship, the PWC is not a trustworthy witness. Now, Lord Socrates, then in para 3, he had gone to PS at 5:30, he has stated in 5:30 p.m. lodged the FIR, but in para 9, he has said for the first time had gone 11:30 p.m. So far as PW8 is concerned, Lordship kindly see 7. PW7 is the mother of the deceased. Because prosecution has relied upon PW6, 7, 8, and 20. So far as PW8 is concerned, you will also kindly see page 123. PW8. Yes, Mullah. Sorry, PW7, sir, Mullah. PW7, 123. But PW6 has stated only father-in-law who telephone demanded dowry. Mullah, kindly bear with me. PW7, what she has stated? Mullah, kindly para 2. Para 2. 4 days after the marriage, Malad got it? Yes. Page 1 to 3. Accused Kanta, mother-in-law, and accused Sujata, married sister-in-law, telephoned me demanding further dowry of 1 diamond set and such and such, such and such. Only she has whispered 2 names. So far as demand is concerned, she has named only 2 persons. One is Kanta and Sujata, that too over telephone after 4 days after. Thereafter, my lord, in the para 2 has said, without outing the accused person, tortured the deceased. Will also kindly see para 3 of his cross-examination. Para 1 to 4. Sorry, page 1 to 4. Though my lord, he has stated in his chief examination, person to demand were given dowry. Will also kindly see para 3. Para 3, my lord, last 3 lines. But we have not given any dowry at the time of marriage. The mother herself has stated we have not given any dowry. Though in the chief examination there was a demand, person demand such thing, but in cross examination she has stated, but we are not given any dowry at the time of marriage. That will also kindly see whatever narrations he had given in the plot's chief and as well as cross examination, you will also kindly see the statement confrontation part, that page para 31, page 176. This part of evidence is not there. You will also can see page 176, para 31. Para 31, my lord, straight comes to page 176. Seventh line starts from, she has not stated in the police case. My lord, got it? She has not stated in the police case before me that 4 days after the marriage, that accused Kanta and Sujata telephoned her demanding further dowry of 1 diamond set, cash of rupees 2 lakhs and 50 tola of gold, and that they agreed to pay and wanted time, and without outing the deceased person, tortured her and they consoled her to it. So 161 statement is not there. That has been confronted to IO. IO has stated in para 31. So this part of evidence was not there. He has not stated before me about the 4 days after telephoning and as well as Muller's torture. So far as PW8 is concerned, we'll also page 1 to 8. He is the brother of the deceased. His evidence that on 16/5/2005, but he came to Jharsuguda and deceased and the PW8 both are proceeding to Pitlagarh. You will also kindly see. My lord.
This part, the deceased told that the accused person
My lord.
This is evidence because this is not the covered.
Exact, my lord.
So
this part is land trial court has relied upon. That's why I am placing. Since land trial court has relied upon this part of evidence, that's why I was trying to impress your lordship that this part of evidence is relied upon the basis of this as convicted. But this part of evidence, but my lord is very, my opine that section 32 of the evidence says how section 32 will apply. In my written note of submission, I have indicated that this part of evidence cannot be covered under section 32. At best, only here's evidence 60. Under section 60 of the evidence act, here's evidence cannot be treated as 32. And that apart, only interesting part is the my lord will see. For the first time, doctor after marriage is coming to the house, and at that time both the parents were sleeping, and on the next day he disclosed before her parents, before his parents, that my daughter, sister was disclosing there was a demand of dowry. That is stated by the PW8. And so far as PW9 is concerned, the same fact. Over telephone, her sister was complaining there is demand of dowry. PW9 has said that my sister was over telephone complaining there was demand, but she has not been examined by police. But the police has stated, yes, I examined her, but she has not stated about the demand or over telephone, nothing has been stated before me. And so far as PW20 also same, PW20 also over telephone he had. And kindly see, my lord, only plot I place page 157, evidence of PW19, that my lord, only relevant portion I am placing that page 157.
The doctor.
Yes, yes.
Salwanti,
Yesterday I placed only PW5. Since PW19, will also kindly only the relevant portion I am placing. The specific case is the para 7. Fifth line from bottom. In fifth line from bottom, 157. In my opinion, the death of deceased was neither homicidal, nor suicidal, nor accidental, but the death of deceased is due to cardiac arrest, and so it is a natural death. Police has not sought for any opinion from the after C report received, and it did not give any opinion out in chemical agency report of the viscera, which is necessary for opinion. After considering the postmortem and chemical examination report, I am of opinion that death of deceased is natural death due to sudden cardiac arrest. But even though PW5 has been declared hostile, well, this is an interesting part. PW5, PP without making any application. Well, kindly see. PP has not made any application on SC 145. But question was, leading question was put. Section 145 Evidence Act, my lord, knows the written petition is required, mandatorily written petition is required declaring a petition as hostile.
No, 154 oral one can also. Oral is sufficient.
But
yes, but only that endorsement has to be there, that at this stage the PP.
But PW19 has not been declared as hostile. I am placing that because since yesterday I placed the evidence of PW5, he has been declared hostile and leading question was put.
Yes.
No, the PW19 has conducted postmortem examination, he endorsed it. PW5 is endorsed. That is the view. Yes. He has given his position. So my respectful submission, since it is a natural death, there is no evidence of suicidal death. There is no evidence of homicidal death. There is no evidence of accidental death. Since it is a natural death, so it cannot be a case under section 302 and 304B. And so far as 490TA is concerned, my lord, I placed the evidence of PW6. PW6 has said there was apprehension. And PW7 has said only Kanta and Sujata demanded dowry over telephone. PW8, 9, 20, all 5 witnesses have said we received telephone call from only blood exception is PW8, brother. Brother had said while we were proceeding to Titlagarh on the way, his sister disclosed before him that there was a demand. So far as PW8 is concerned. Although PW6, 7, 9 and 20 all have said we got telephone call, there was a demand of dowry. Even if not demand of dowry, in absence of torture or cruelty, so there is no question of 490. But so far as medical evidence concerned, what my Lord Senior admins, but I have gone through the Harrison, I have gone through the bandits, all records I have. if my seniors will rely upon the medical evidence, definitely opportunity will be given to place all the medical evidence. Whether the Table 5 and 9 are correct or wrong.
This is by Mr. Pradhan.
No, last, I had given only bullet point, I had not given details written note of submission.
One important question, you have to answer that question. Because you are appealing for the informant.
Yes, my lord, your question may ask me.
Regarding the death, whether it is an unnatural death or any way it is homicidal death of any category.
So if your lordship kindly appreciate 304 or B.
Yes.
But the basic requirements that has been classified by the court also, the trial court while actually examining the matter. Death of the deceased, your lordship, these are the basic things which should be examined by your lordship. The death of the deceased was caused by burn, bodily injury or otherwise than under the normal circumstances. Here, this is a case of death, otherwise than in normal circumstances. But why actually the affair has been filed at 11:30 p.m. and all those things I'll explain, Your Lordship. Is about 300 kilometers or 240 kilometers away from the place. They got the information, they came in a car. Your Lordship knows that.
No, his allegation is very specific.
Your partner?
1:15 p.m.
Well, he has said he reached around 2:30. The first thing actually they have to see the girl, see the person concerned, go to the hospital, all those things are there. So you cannot just say that the moment you arrived, you have to file a lodging affair. And then there is no delay as such for lodging the affair. But here it has to be kindly see the anxiety of a father. He comes with his relatives to knowing that his daughter has married 4 months ago and she has died. She was hale and healthy, no disease, no ailment, nothing has happened, and death has happened. But one question was raised that there is no material to show that they were together in the room, sleeping together. But the statement of the accused itself shows, morning at 5 o'clock, I got up and tried to wake up my wife. But they filed the information to the police.
No, because the hard medical evidence, they are not usually the ordinary witnesses.
Right.
This is the death due to cardiac arrest. A simple and blunt statement they have made. So overcome that.
Yes, my lord. I'll explain, your lordship. The doctor's evidence, PW5, if I read it carefully, my lord, they're all gagged, my lord. With due respect, I'll just read it, my lord, again.
Agree to this submission.
Right.
It's all gagged. The court will definitely search out for the alternative evidence on the basis.
Exactly. Exactly.
But where is this evidence? There is no evidence beyond these two persons. Others are all, they are seen on the face. They are not the competent witnesses to say.
They are not competent witnesses to say.
Exactly. So there is no witness about the death. Even there is the evidence about the death, there is no evidence. Both the way the accused will be get the benefit.
Well, that is exactly I wanted to answer, your lordship. Your lordship's query is absolutely justified. Here in this case, if your lordship looks at the medical evidence, but if we discard the medical evidence even, the third opinion has to be taken by the court. Court has to see a person cannot as such die. A normal person cannot die in cardiac arrest. A normal person, there is no ailment,
is very difficult to believe under any fathom of
I
imagination.
can give you 500 cases. That even nobody could detect that he's suffering from the serious heart block. One night there is a simple uneasiness died.
Absolutely correct, Malad. That's possible. But the question of possibility cannot be made applicable because she was hale and healthy talking to everybody and there is no symptom or no sign of anything, Malad. But I can understand any symptom prior to that. But your lordship knows cardiac arrest doesn't come suddenly. It doesn't come suddenly. They say it knocks the heart or knocks the door 9 times. If I suffer a cardiac arrest, there must be symptoms 9 times before that. That is the theory of medical jurisprudence.
And the problem is that this person must be very alert to hear the knocking at the door.
Right.
That the normal persons ignore that it is nothing. It is an uneasiness.
Exactly, Malad.
That is the thing.
But here the question is, a 22 years lady.
How can this can be the evidence in the case? Sure, it's a very simple question. We are just confronting. When the doctor, set of the doctors, one doctor has been declared hostile. I do not know why he has been declared hostile because of his opinion. He is not supporting the prosecution case. That cannot be the ground declaring someone hostile.
No. I'm
set principle for declaring a hostile.
But I am
deviating from his own statement recorded by you of the report or endorsing the report. He has not deviated a single inch from.
No, he has suppressed one fact which was disclosed subsequently. He was the family doctor, visited early morning to the house on being called. He declared the person to be dead. No certificate was given. Then he came back. He claims that he has been asked to do the autopsy, but he did not do it. Dr. Joseph did it. And he signed the. But a single one doctor could have done it. But now both were present. But he said, he prepared the report, I signed it. But he was a senior most doctor in the hospital. But he went there, he gave a declaration from the morning itself, he knows the cause of death. But all these things were not disclosed. It was also disclosed by the IO subsequently. He did not report to the police that he had visited the house. But he knew the cause of death. He did not disclose it. He came and did the autopsy. But keeping in all those things, if you also reads the statement, but after declaring hostile, he has been put by the question by the defense, not by the prosecution.
Yes.
But defense, obviously, he has given a favorable answer to the defense questions. Defense question is whether he died. If you also kindly look at.
He has also admitted in paragraph 3.
Yes. 100 page 108 if you also looks at.
He has admitted in
So what is the, I did not understand that your observation, what is the favorable question? How is the criminal could be answered? It may favor the defense, it may favor the prosecution. On the basis of that, the character of the witness cannot be decided.
No, I'm not saying that character of the witness to be decided. What I beg to bring your lordships, but what I beg to submit for lordships is that a person who visited the deceased from the morning itself knows the cause of death. But he has, I don't know, but he has thought what answer is to be given at the time of disclosure to the police or disclosed to the, at the time of examination and autopsy.
Yes.
He has not disclosed the truth. In fact, reason being, in the chief examination, he has not disclosed the reason. He has not disclosed the reason. He has disclosed it only after the cross-examination by the defense. And he has tried to justify it by saying that the cause of death is this, because this, all those things have been stated. But if you are carefully, if I have gone through the carefully word, it shows he wanted to justify that it's a death due to cardiac arrest. Well, death due to cardiac arrest cannot be detected without any symptom. With the medical jurisprudence, but if I have died due to cardiac arrest, there must be some symptom of cardiac arrest. They have not disclosed what was the symptom for which the cardiac arrest happened. But your Lordship knows there are many cases, must have come across my lord in practice and also in this presiding over this justice my lord. But there are cases when a person sleeping in the morning is found that he is dead. What happens actually, doctors on examination, they found that saliva used to secrete from the body, it comes to the mouth. From the mouth, when it goes inside, when sleeping condition, sometimes the lungs tract gets opened and it enters inside. As a result of which, the respiration gets choked and the person dies of cardiac arrest. So there must be some symptom which could have resulted in the cardiac arrest. But both the doctors have not expressed anything about that. A hale and hearty person, if he dies, there must be some symptom, my lord.
And this question was put to the doctors. Whether this question was put to the doctors.
But he has not, he says the cardiac arrest.
Whether the prosecution also, when the doctor was declared hostile, this particular question now you are raising has been put to the doctor.
But prosecution has simply not put any question, only one question has been put. If you also look at the prosecution question, he has declared hostile.
I am asking you.
Right.
Defense will obviously not ask that question.
Right. But sir, my lord, I kindly appreciate, if the doctor says cardiac arrest, the prudence requests the doctor has to explain what is the reason of cardiac arrest. It is not that simply you will say that is a...
I'm really, because it is very, you are very experienced counsel. The problem is that doctors is treated under section 147 as an expert.
Right.
Both under section 145 and 47 both. Because if some doctor doesn't sign and other doctors, he can identify also the signature of the postmortem. The problem is that the limitation to cross-examination expert has been provided under section 51 of the Evidence Act.
Expert, right.
What you can question? You can question the expertise of the doctor, you can question the process of the doctor, you cannot question the opinion as such unless you question these two or other two factors.
But sir, law requires that if a doctor does post-mortem examination, he has to not only speak about the external or internal injury, but he has to express the opinion. Here the opinion must be an opinion basis on which the thing happened. Opinion cannot be a bald opinion, yes, he has died due to cardiac arrest, or there was a failure of respiratory. But you must give reason why this has happened. This opinion is one of the mandatory requirements who does the autopsy.
You can argue there is a difference.
No, that is the law requires. Supreme Court says that.
All right, show this judgment.
But say judgment I can do, opinion of doctor. There is I'll give the judgment. He has to give reason while expressing the opinion. He has to give the opinion. But here he has not given the opinion. He has been asked to say how it happened, what was the cause of death, and say this is not, therefore it is cardiac arrest.
Well, the form itself there is a cause of death. Form also contains this.
In the postmortem.
Yes, postmortem
report. The doctor is bound to fill up the any column of the report.
Yes, the postmortem report did not give any cause of death. In spite of there is a form to that effect. What we have said, that opinion cannot be expressed in the absence of any chemical examination report. He did not give the opinion then. He has only given the opinion only in cross-examination after declaring hostile manner. But once he has been...
Yes.
If Lordship lectured.
No, they have not mentioned. Where is that postmortem report?
Page 108 if Lordship looks at.
Of the paper book? Of the paper book?
Yes, ma'am, paper book.
No, paper book nahi. Exhibit 4 lots of can live in the...
No, paper book, sir.
Paper book.
Okay, but exhibit 4 is...
Exhibit 4 must be in the report.
No, sir, paper book.
Yes, ma'am.
Yes, paper book does not contain PM report.
I'm going to the exhibits.
Only consider. Only consider. No, go to the film. तो लिखा ही नहीं
नहीं for lots of immediate perusal, I am just giving the PM report.
Opinion reserved. Viscera preserved.
Opinion reserved. He has in page 108 of the paper he has stated.
File is not signed in this report.
Yes.
Arun Kumar Das.
Page 108 of the paper fellowship looks at the PW5 statement.
Yes, signed. Signed.
PW19
signed. Arun Kumar Das.
Yes, yes, it's there. Yes, yes, I've seen it. It is there, my lord.
Presumably concentrated common solutions. Time since death is 24 hours prior to postmortem examination. Opinion reserved. Viscera preserved for chemical examination. The report was prepared by Silent Jojo. I have signed it. Exhibit 4 is my report. Exhibit 4/1 is my signature. The postmortem report was written by Jojo. Exhibit 4/2 is the signature of Exhibit 4 postmortem, and Exhibit 4/2 the prepared in my presence. And it page 154, PW19 Marad.
Dr. Jojo.
Page 154, second paragraph. Preservative concentrated common salt solution. Time since death is 24 hours prior to postmortem examination. Cause of death opinion preserved. Activity reserved. And viscera preserved for chemical examination. Only in cross examination the opinion has been given. So may I just place actually the same thing has been dealt with, Melody, as you also rightly put the question to me. Page 45 of the impugned judgment.
Yes. If you want to read it again, you can read it.
Page 45, Melody. I just saw something, Melody. The doctors have also not given the cause of cardiac arrest, stating that though there are several causes of cardiac arrest, many of them are not detectable in postmortem report. There may be truth in it that it may many such cardiac arrest may not be detected, but with reference to the opinion of the doctor and that one can die within 1 hour of postmortem symptom, it is normally expected the part of the doctor, PW5 was called by accused person to their house. There he declared the deceased dead, notice such symptoms. But strangely enough, evidence on record is totally silent about any inquiry made by the doctor. PW5 about any symptom of the disease immediately prior to the death or about the history of the ailment, or nor the accused person express anything about the condition of the disease immediately before her death or her suffering at that time. From the next relied upon by both the sides, it appears that cardiac arrest takes place in case of death and it is a symptom and it is cause of many causes are many. Therefore, simply saying that it is a case of sudden cardiac arrest without saying that it was unexpected and accompanied with some reason or ailment immediately before the death, the opinion of the doctor appears quite immaterial for the purpose of the issue of this case. The queries by the doctor about the death would have thrown some light to the immediate cause, which though may not be detectable in postmortem. But the problem with the doctor in this case is giving opinion by them death is due to cardiac arrest, which is natural death, without going to the cause of cardiac arrest. In such a situation, when it is not possible to ascertain the cause of death, according to Parek's textbook of medical jurisprudence and textology, when in some cases, in spite of thorough postmortem examination, chemical analysis, microscopic examination, cause of death cannot be arrived at, medical officers should frankly admit that cause of death is not known to him, and there is no loss of prestige in saying so. In view of such confessional ethics, the professional ethics, the doctors should have been reluctant to give a clean chit to the defense in such mysterious circumstances of death of the deceased, utilizing which is a trump card of the defense is seriously challenged the prosecution, having failed to prove under such circumstances that death occurred otherwise than under normal circumstances. But that's the reason why actually, after going to the report of the doctors, both the doctors, the court has also dealt with the matter to say that this is death which is otherwise than in natural death. But that decision, Your Lordship, I wanted to cite that AR 92 Supreme Court, is 2186. AIR 1992 Supreme Court 2186, which says that it is needless to say that the doctor who was examining the disease and conducted postmortem is only competent witness to speak about the nature of injuries and the cause of death. Yes. That is what exactly I wanted to. That is what I was also pointing. Exactly, madam. Here actually they did not speak about the cause of death. The postmortem report doesn't contain the cause of death. They kept it till the chemical examination report. And here in cross-examination, by the defense, they're saying all those things, explaining everything. But the way they have tried to explain, because the defense counsel obviously asked questions which will be favorable to them. And those are answered in a way that as if he knows about that it has happened in cardiac arrest.
We have got the visceral report also.
Yes. Yes. Visceral report is subsequently obtained.
Yes. Obtained and there has been placed in the record. Record is there.
Yes, that's the best.
No absence of any cause or anything else. No.
But there is money.
You just also see the inquest report. No apparent injury, nothing of that sort.
No, that is the way it has to be unnatural, Bharat. It is not in the natural process of death. Bharat, question is, Bharat, I'm just asking a question to myself, Bharat. I'm not telling you, Lordship. But if a pillow is put on the face while somebody is sleeping, there may not be any, because in sleeping condition, there may not be any struggle.
No, because the pillow causes SPG. There is a cloth in the nostril is an essential equipment. Because someone was gulping for the air, bleeding, clogging, and these are the common phenomena.
So bleeding was there. There was bleeding.
Sure, evidence.
Yes, yes. Well, if you also kindly see the evidence itself, it is there. So if your Lordship looks at page 180.
Yes.
Page 180, if your Lordship looks.
180.
180.
That chemical examination.
Yes. Result of examination. Human blood strain could be detected in the exhibit marked as exhibit A. A is that bedsheet that is there. But if your Lordship looks at the evidence of the IO, he said on first day, he sees the bedsheets and everything. Fourth day, The chemical examination experts went there and they detected it. They again seized it.
No, blood, whose blood? The court cannot stop there. Blood on the victim is already whose blood?
Already, it's a human blood, man.
All right. Whose blood again?
Well,
It can be the third person blood also, who is not unrelated to the case. Husband blood also, unrelated to the case. And where from the blood has come, if there is no injury?
So actually it comes from the, say, it comes from the nostril itself. Or in such cases, it comes from the nostril or the mouth.
No, that has been stated that fluid and blood stain was there. No?
Yes. That is also there, Lord. If your worship looks at, blood stain was there, they have detected that blood has coming out from the mouth and also nostril, Lord. They have also detected, Lord. What they try to explain, but they say that during inquest, actually, if they turn the body this side, that side, then blood may come out. So blood may come out if it's a case of 24 hours after it is done. It will not immediately after the death.
No, sorry.
But it is only immediately after.
Ultimate question you have to face.
Right.
Supposing all the evidence that you are indicating to us is accepted, on the basis of this evidence, where we lead to for our inference.
So the inferences, if your worship looks at, it is not a natural death. It is not due to burn or anything else, Marat. There is allegation in the sense substantiated by 5 to 6 witnesses that there was demand of dowry. So torture in the sense, it may not be a physical torture, you know, so not cruelty or torture.
No, but if I may pause you for a moment.
Sir?
You see, all this leads to only a suspicion. Suspicion cannot take place of proof.
Sir?
Maybe very high, but...
You are absolutely correct. Suspicion cannot substantiate the question of proof. But if you are kindly look into the totality of circumstances, but what it leads to, a person who demands dowry and harasses the lady may not be physically, but harassment may be. There are cases where actually you abuse the father, abuse the mother in presence of the daughter. Those are all tortures, Manad. Those are tortures which cannot be expressed to anybody else but to the relatives. Sometimes the daughters keep quiet and suffer. Sometimes they express to their relatives. So that happens actually in our society, Manad. But in such circumstances, there is a threat also. The father has said, on telephone, they say, if you don't give, then the possibility of killing the daughter. But those inferences has to be drawn if a husband and wife sleeping together. In fact, they were together.
Do you think this is the legal evidence? Is by telephone, someone demanded money.
Right.
Is it legal evidence according to you?
Sir, there's a consistent evidence, not the telephone by ones. The PW28 met the girl. They have also, if your lordship looks at the evidence of, from the evidence of PW28 also met the daughter. Daughter was there at their place and disclosed it. But all those are straight discussion and they have disclosed directly without telephone conversation. Telephone demands are also made. Somebody says that I was contacted with telephone. But those are all narrated in the FIR also, if your lordship looks at that. FIR, they have given details. It is not that it is not disclosed in the FIR. It's the first time somebody is claiming that there is a case of dowry death. If your lordship scrutinizes the evidence of all those witnesses who are the close relatives of the deceased, to whom she has confided or disclosed, and the FIR that has been given, it reaches to an irresistible conclusion that there has been a demand of dowry. And the previous amount that was paid, the father has said, I gave it not as a dowry, but I have given it as a given to gift to the daughter and the son-in-law. Still, 4 days after the marriage, the demand was made. It continues, my lord. It is not that because we have to find out actually immediately before the death such a demand was there or not. So immediately means it's a case of 4 months only. Continuously is continued. That you have to satisfy the demands further. And let's note the anxiety of the parents and the stress on the parents If they have given their daughter marriage, they have no money. They have to meet the demand. So they have to arrange. So all those things are there with them. And this is coupled to the fact that they're apprehensive about their daughter's life also. Then the news comes that she is dead. And who gave the news? The father-in-law's, daughter's father-in-law's brother. And all of them have left. They never stayed in the house. When they came, nobody was there except the elder father-in-law and mother-in-law. They said we lost, an UT case was lost. And subsequently, FIR has been filed. But we have to look into these type of cases. We cannot get any direct evidence on the point to reach at a conclusion. So this is a one peculiar type of case where to see the surrounding circumstances, the basis on which actually this has happened, and actually what is the reason. Maybe it may be, we have to find out that it may lead to the conclusion that it's a case of death due to dowry structure. This is what, if you're a totality of the circumstances, if you looks at, and the FIR itself, I don't have to read and take your lordship's time, but in the FIR it has been detail given. They have nothing more to do, Melody. It's a case of 1-to-1. Only the husband and wife there in the room, nobody else. I'll also give a small note to justify, and the distance are there, 3-4 distance are there to substantiate my argument. And also keep that. The role of a hostile witness, how the court is to approach, all those things are there codified for it.
May I please, Manoj? Because the very postmortem report has been exhibited as Exhibit 4 without an objection. And also, Kyle Perus, the reports I have handed over to Lordship. The very fast pace I have highlighted. Thorax loss of right lung and left lung. Intact, normal, and congested. I put emphasis on the word congested loss. Then loss 7-column heart. Left ventricle is empty. Loss, you got it? Yes. There also I put emphasis. And on the next page, loss. Blood mixed fluid is present on both nostrils and mouth. So this will not happen in a case that if it is a case of cardiac arrest.
It will not happen.
No.
How?
I will explain your lordship. When I am making a statement of a lordship, I have to explain it. Because heart is a part of circulatory system and lungs is a part of respiratory system. And heart doesn't have any connection, direct connection with the air passages. Because the air passage is connected to lungs. So deoxygenated blood enters into the heart, then it pushes into the lungs, then the lungs gets oxygenated, then again it comes to left ventricle after getting oxygenated. Then from left ventricle, it goes to the entire body, passes to the entire body to supplement oxygen. So there is no air passage direct link between the heart and the air passage. So here, unless there is a rupture in the lungs, then blood will not come out to the nose, nostril or mouth. And here there is, when there is blood in the nostril, blood mixed fluid is present both in nostril and mouth, that itself signifies that lungs has been ruptured. Further loss, so for a right ventricle and left ventricle, I would like to show lordship some photograph. Heart loss, how the heart functions. Also, I can show it if the lordship permit. Yes. In the pen drive, you also can see the column cross section of the heart as well as how heart is functioning.
Not required.
You'll also can see to the superior vena cava and the inferior vena cava, deoxygenated blood enters into the heart to the right ventricle. I mean to the atrium, right atrium.
Yes.
Then it goes through. You'll also kindly see there are 4 valves. One is tricuspid valve, that is between right atrium and right ventricle. And there is a mitral valve between left atrium and left ventricle. So usually through superior vena cava, through veins, the deoxygenated blood enters into the heart, to the right atrium. Then it's through pulmonary, through tricuspid valve, it enters the right ventricle. And when right ventricle is filled up with deoxygenated blood, then immediately it enters into the lungs through pulmonary valve. You also can see the pulmonary valve, because there are 2 valves. Out of 4 valves, in the right side there are 2 valves, in the left side there are 2 valves. In the right side, there is tricuspid valve, the first one. Then blood goes from the right ventricle to the lungs through the pulmonary valve. And then after oxidization, after getting oxygen, through pulmonary vein it enters to the left atrium. Then from the left atrium, through mitral valve, it enters the left ventricle. That is oxygenated blood. So when left ventricle is filled up, so mitral valve is shut, then it enters into, through pulmonary artery, it goes to the entire part of the body. So this is the whole system, how heart functions. So heart is no way connected with any air passage. It is only connected to the lungs. Because I am showing you outside. It is also Modi's text. I can give the original book. It's all right. Where is Modi's? You also can see page 599.
Copy do give him a copy.
Copy the original copy. I'll copy. No,
didn't.
Copy. The original book. Page 599. Yes, I'm reading 20 point. It was 20.5.6.1.1.
Which one?
20 plus paragraph 20.5.6.1. The problem that is highlighted.
1, 2.
Yes, 20.5.6.1.1. 1.1, then I'll go to 1.2, then I'll go to plus last line I'm reading. Of course, no local signs of violence will be found if a soft cloth or pillow has been used to block the mouth and nostrils.
Yes.
Then I am going to 1.2. Appearance due to asphyxia. Here we'll get from third line. Bloody froth comes out of the mouth and the nostrils. Then internal appearance is lost. Rats, mud, or any other foreign matter may be found in the mouth, throat, larynx, or trachea, when suffocation has been caused by the impaction of a foreign substance in the air passages. It may also be found in the pharynx or the oesophagus. This is not our case, plus. The mucous membrane of the trachea is usually bright red, covered with bloody froth and congested. The lungs are congested, plus. And emphysematosis. The lungs has to be congested. I will explain why lungs will be congested. Then we'll also we can come to next page. The lungs may be found quite normal if death has occurred rapidly. The right side of the heart is often full of dark fluid, blood, and the left empty. This is the plus here in our postmortem report. The left is empty. And why left is empty also I will explain also. Well, then 20.5 and 7.2. I'm coming to the second paragraph. As a charge of modern may follow, the autopsy surgeon should be aware of the gravity of the situation while removing the gag from the mouth and should make a note as to how the cloth piece is wrapped. Here it is not the case, but homicidal suffocation is common and is usually resorted to in murdering infant and children by forcing mud down in their throats or by loss. I am coming from this because I was smothering them by the hands, cloths, and soft pillows. In adults, it is only possible if the victim is weak and feeble or is unable to resist, having been previously stupefied by intoxicating or narcotic drugs. Suppose drugs have not been found out here in this case. So Modi's jurisprudence says, in a case of asphyxia, only bloody froth comes out of the mouth and the nostrils. As it clear from paragraph 1.2 laws.
Just I have one question before you are going us to the textbook.
Yes.
And forcing us to infer the certain opinion. Whether these questions are put to the expert came as the witness.
It has been put to.
Because you had got
it has been put to us. It has been put. And the question has not been rightly answered by the doctors. That's the reason why it is inherently defective. That's the reason why not this court can substitute your lawsuit's opinion over that.
Opinion, but certain matters.
Yes.
Court cannot always substitute opinion on the basis of the textbook.
But no, you also can find. I am just doing a lawsuit to the evidence now.
That is sure.
Yes.
But how this matters are dealt by the expert.
Yes.
Then come to the
Yes. I am coming. One particular what I have submitted that Exhibit 4 has not been objected, that you will also get it from page 108. That's clear. Then I pray also to come to page 109.
109 5.
5.
No, we come to the 19. Who actually conducted the question?
Both have conducted the autopsy.
No, he says I was observing. And he conducted the question.
Because I am taking also to page 157.
Yes.
I am a specialist in pathology. I have just completed 5 years of service in District Headquarters Hospital, Jharsuguda. There are many medicine specialists in the District Headquarters Hospital who attended the cardiac patient. In normal course, we didn't deal cardiac patient maybe. Plus, in emergency case, we requisition the medicine specialist. I have no experience of treating the cardiac patient. Dr. A.K. Das, PW5, is the senior most medicine specialist of the District Headquarters Hospital, Jharsuguda. Cardiac arrest may be possible without the cardiac thrombosis and cardiac. Infection even in a healthy young person. Skipping pills can be detected in the viscera in chemical examination. If mouth and nostrils are gagged, that will be death due to asphyxia. This is not the death due to asphyxia. In the present case, death of deceased is due to cardiac arrest and mode of death symptomless. In case of gagging of mouth and nostril, lungs may spongy and secretions may be deposited in lungs. That is the reason why lungs will be congested. In the present case, there is no deposit secretions of lungs, nor it is congested. How can she say when the lungs itself has been congested as Exhibit 4 displays? Lungs congested. Because I will explain also how the lungs will be congested in a case of asphyxia, not in a case of cardiac arrest. Because cardiac arrest means it is just stoppage of heart. Heart is functioning, cardiac arrest is stopped. 2 to 3, 5 seconds after the breathing will be stopped, but the heart will stop as it is. Right ventricle, whatever it is carrying blood, that will be as it is. In the left ventricle, whatever blood is being carried, that will be as it is. Because the heart will stop automatically. But here in a case of asphyxia, because things are different. Because I will explain why the left ventricle has become empty. So one way saying is that in the present case, there is no deposit secretion of lungs, nor it is congested when Exhibit 4 itself says that lungs is congested. So there it is in that way, the very opinion of the doctor is inherently defective. And that I am supplementing by showing a lot of other medical jurisprudence. Also, I will show the writings of two authors. Then they are bound to occur marks of violence in process of struggle in the case of such gagging. But no such mark of violence is detected in this case. The fibers of the soft cloth or pillow be there on the mouth of deceased, which I don't find in this case. There will be also a mark of nostril and lips and stains of mucus on the pillow or soft cloth, which too were not noticed in this case. In my opinion, the death of deceased was neither homicidal, nor suicidal, nor accidental. This is total confusion. But the death of deceased is due to cardiac arrest, and so it is a natural death. So, when is one way giving the opinion that it is a cardiac arrest, is a natural death. The other way is whatever she is giving the opinion, that doesn't stop, that is not corroborated to the postmortem report. Because I will show Lordship why the lungs will be congested in such a case. This one. Essentials of medicine, page 130. That clearly speaks about what is asphyxia. Because under the heading asphyxia, asphyxia is a condition caused by interference with respiration or due to lack of oxygen in respired air, due to which the organs and tissues are deprived of oxygen, together with failure to eliminate carbon dioxide, causing unconsciousness or death. The term asphyxia indicates a mode of dying rather than a cause of death. Young and middle-aged adults have almost complete saturation of their arterial blood with oxygen at a level of 90 is to 100 mg in medical terms. In persons above 60, between 60 to 85 millimeter. In severe to fatal asphyxia, it falls to between 20 to 40. So then comes is important. The brain weight is about 1.4% of body weight, but it uses 20% of total available oxygen. Nervous tissues are affected first by deficiency of oxygen, and their functions are disturbed even by mild oxygen lack. In total ischemia of brain, cessation of nerve cell function in the cerebral cortex starts after 8 to 15 seconds, and in the brainstem ganglia after 25 to 30 seconds. Irreparable damage occurs in the cells of cortex up to 3 minutes, In basal ganglia after 6 to 7 minutes, in vagal center after about 9 to 10 minutes. Subnormal oxygen in the blood supply to the brain causes rapid unconsciousness. This is important, fellows. In all forms of asphyxia, heart may continue to beat. Here it is important, fellows. Heart may continue to beat for several minutes after stoppage of respiration. The rule of thumb is breathing stops within 20 seconds of cardiac arrest. If cardiac arrest, breathing stops within 20 seconds. And heart stops within 20 minutes of stopping of breathing. If it is asphyxia, plus heart stops after 20 minutes. And within that 20 minute plus, what happens? Because heart is working for 20 minutes. So from the right ventricle, blood moves into the lungs, but only oxygenated blood comes to the left ventricle. If deoxygenated, it will not come. So because it doesn't get oxygen, because of the respiration has been choked, somehow or other, due to smothering or for some reason, somehow there is no respiration, so there is no oxygenation. So oxygenated blood will not come into left ventricle. So whatever blood, oxygen blood will be there in the left ventricle within 20 minutes, that will turn down. So that is the reason why there will be empty, left ventricle is empty. Again, I am reading close. The rule of thumb is breathing stops within 20 seconds of cardiac arrest and heart stops within 20 minutes of stopping of breathing. If the heart functions for several minutes after stoppage of breathing, the weight of the lungs may increase to 450 to 500 grams. Then it is congested. Of course, here the measurement has not been taken by the doctors.
That is where actually I wanted to point out.
Yes.
If a massive cardiac arrest takes place,
yes,
that also affects the lung.
Yeah.
Immediately within
yes
20 seconds, actually, there
yes.
of course is
Yes.
20 seconds. Then if the lung become heavier,
yes,
there will be the shortage of oxygen.
Yes.
Right? And a certain sign of asphyxia can be found also in such circumstances.
Yes. That is congested. That they have said that is congested. Lungs is congested. And added to that, plus left ventricle is empty. So for 20 minutes, because it is a case of asphyxia, for 20 minutes the heart worked. So the entire blood, oxygen blood has been drained out. So it's a clean case of asphyxia.
All right. That's all.
Plus once it is asphyxia, less others will follow. Because 302 then loss. For a moment, just I am adding PW8 loss. The version of PW8 has not been put to confrontation to the IO, PW21. You also find PW is very consistent. Again, I am reading loss per moment. Just plus because time is over, still I am reading. You will also get 128. 128 PW8 stars.
Who is the younger brother? He is the younger brother of the deceased.
Yes, yes, tell what this is. I am the younger brother of the deceased. I know all the accused persons. The marriage of deceased was held with accused Vimal on 9/5/2005 at Jharsuguda. On 16/5/2005, I came to Jharsuguda and took the deceased to Titlagad with me. When I came to Jharsuguda on that day, I didn't find any hospitality towards me by the family members of my brother-in-law, Bimal. On our way to Titlagad, the deceased told me about the torture upon her which could not tell due to obstruction in her in-laws' house. The deceased told that the accused persons were demanding for the dowry 1 diamond set, 50 tolas of gold and cash of rupees 2 lakhs, saying that unless she would bring, that she will not return to Jharsuguda. That time I found her quite nervous and pale. Returning to her house, I disclosed about the torture to her to my father. On 1/10/2005, my mother told me about the death of deceased. Thereafter, I along with my parents and sister came to Jharsuguda. Going to the in-laws house of the deceased, I found the deceased were lying dead in the bedroom. Well, always everybody says it's a bedroom. At that time, I also noticed coming out of blood from nostril here, my was fine. At that time, I also noticed coming out of blood from nostril and mouth of the deceased. After cremation of the deceased, we returned to Titlagad. Coming to Jharsuguda, we found gathering in front of the house of the in-laws of the deceased, but I don't remember the about 50 or 100 or more than that. Except Santosh Kedia and his wife and the accused person, I don't know anybody at Jharsuguda. You know, Santosh Kedia happens to be one of our related to him. I didn't talk to Santosh Kedia and his wife. I do not remember if I saw Santosh Kedia there. I have not visited the house of Santosh Kedia and I have not met Santosh Kedia or his wife. I don't know anything regarding the occurrence. Till today, I have not talked with Santosh Kedia or his wife. I have not disclosed to anybody about the torture to the deceased on 1/10/2005, but I have disclosed to the police about 10 to 12 days after the occurrence at Jharsuguda. At that time, my parents and sister accompanied to Jharsuguda, but I have not disclosed anything to any outsider about torture or conversation with my sister. I disclosed to my father on 17/5/2005 about the conversation between me and the deceased. I came to know about further demand of dowry from the conversation with the deceased on our way to Titlagarh for the first time. By the time we reached Titlagarh at 10:30 p.m., my parents were asleep. Though my parents got up from sleep, after reaching there, we didn't disclose about our conversation. We didn't talk the deceased to doctor reaching at Titlagarh on 16/5/2005. Take the deceased to doctor, sorry. From the conversation, I could guess danger to life of the deceased from the side of the accused persons. But except reporting my father, I have not taken any other step. I had never told my father not to leave the deceased to Jharsuguda till the amicable settlement is made with the accused persons. I told my father that the life of the deceased was at stake at Jharsuguda. 10 to 15 days thereafter, the deceased returned to Jharsuguda, but I don't remember who escorted her to Jharsuguda and the precaution measures taken for him. Coming to Jharsuguda, we stayed in the Dharmasala on the date of occurrence. I don't remember about any arrangement of our putting at that time. We reached Jharsuguda at 2 p.m. on the date of occurrence, that is 1/10/2005. Until 4 p.m. we were in the house of the accused, and thereafter we went to Dharmasala, and I along with my parents and sister and others stayed there till 7 p.m. And thereafter we all went to cremation ground and returned from cremation ground. I don't remember if anybody went to PS at Jharsuguda to lodge the FIR. It is not a fact that my father was not at the cremation ground. It is not a fact that I am reposing falsely at the instance of parents and sister. And the deceased are never told about the demand of a dowry. I am taking lawsuit to the version of period 21, the IO. That is at page 163. It starts from 163. But I am taking lawsuit to page 176.
Let me continue. It is already 45 minutes.
I can finish another 5 minutes. You will also right. Plus 176. Page 30, para 32. I examined Gaurav Agrawal, PW8. Only once in the UD case and only once in the PS case. I examined him in the PS case on 14/10/2005. At the PS, he came to the PS with his father and sister. Then nothing has been put to him. Then it came to period 9. I have examined Tanishka Agrawal, period 9, on 14/10/2005. And that para then thereafter relates to only period 9. So whatever PW8 has stated, that has not been confirmed to the IO. So the entire evidence of PW8 that remain consistent was.
No, but has he said so in his 161? It is still open to the court to verify the 161.
Even no contradiction, no question to contradict.
Maybe the defense may have forgotten to ask that question. Still, if it is not there in the yes 161, the court can take note of it. Supposing he says something in 161,
yes,
and says a different thing in the court,
yes,
but the defense has not confronted him,
yes,
still the court can take.
Yes,
court can take 161.
Court can. That is always there. Very well, he could have been called for further examination also. And yes, the FIR will also find the Gajanan Agrawal, PW6, the father, has detailed about the allegation of dowry torture. Of course, in the 162 statement, whatever has stated that, because while confronting the IO has stated that he has not stated.
The dowry torture relatively of the 3-4 days of the marriage, that one episode.
Yes, ma'am. Yes, ma'am. It is only 5 months plus. Marriage and death, it is only 4 months.
No, because soon before the death.
Yes.
It has to be interpreted in a manner that we have to examine whether that particular incident has got any effect on the impact of the person. Usually using a suicide. That is a factor propagative or not. That we consider that way. But here also soon before the death there was any harassment.
Yes.
So how far it is to elasticity to be?
But there is judgment of the Supreme Court to that extent.
No, it says that it must show that some effect of.
Yes, yes. And there is continuity loss. There is continuity. So far as the allegation of torture is concerned. And if it is not less than 302, if it is asphyxial death, it's a case of 302. And was Laren trial court, because in one judgment, that is Krishna Master versus State of UP, there Honorable Supreme Court has held that is always the trial court has the advantage of watching the witnesses in the dock as well as the accused persons. What usually the appellate court doesn't have. So usually the whatever opinion has been formed by the trial court, that should not be set aside without finding that yes, in some way or other, that is was perfunctory. Or in this case, was even if
no, this is a matter of the delicate balance.
Yes,
that someone is seeing the witness and we are not seeing.
Yes.
We are only seeing through the words. That how he might have talked to the trial judge.
And it's a very poor man, almost 22 years old girl has been killed in such a manner, and some principal witness have turned hostile.
That is why we have to searching for the evidence.
Yes, and evidence I have already placed on.
Because you are already in half doctor. 2 months short of being the
But 2 pages can you see? Page 90, if you see, can you see?
Page 90.
Right, 90.
Yes.
The statement of the accused, my lord. Question number 28.
That's an ODR. That is the ODR. That is an ODR. My lord will not.
1/2005, Sakal 5 uthi, got up at 5 o'clock and tried to wake up her Manisha. She was senseless. He then called the other members. The doctor says at death might have happened at 5:30 to 6. Doctor's statement is page 111.
No, there is a projection. But there is a projection that this is the tentative time that there is a statement. There is a decision also. This is not the exact time. But we can get a time range of the
small embellishments. And here a UD case as unnatural death case has been registered at the instance of the Bimal Khetan, the husband.
So far as medical jurisprudence is concerned, what my learned friend has advanced his argument, that my lord will find from the first medical evidence related chapter 20, death from aspasia. If you, my lord, kindly see that the chapter deals with death from aspasia. What would be the features of aspasia? These are the conditions has to fulfill in respect of aspasia is concerned. But if you also will find the Harrison, if you, my lord, see the Harrison,
what the opinion?
Those, some of them do those. Harrison and as well as what Broncoal's heart disease. In case of cardiovascular collapse, which page? Which 499? Page. Yes, that page 2059. Harrison 2059.
There's no page marking.
Harrison, my lord.
2059. Yes, yes. Yes,
I got it. My copy of Harrison, my lord. In case of cardiovascular collapse, lots, no feature will come. The autopsy doctor cannot get any feature. And within 24 hours, it will be done. Sorry, my lord, you will also see. They have stated that cardiovascular collapse is severe hypertension from acute dysfunction of part of peripheral vasculature causing hypertension with resulting cerebral hypofusion and loss of consciousness that can be the result of cardiac arrhythmia, severe myocardia or valvular dysfunction, loss of vascular tone, and acute disruptions of venous return. When an effective circulation is restored spontaneously, patient present with syncope. If spontaneous restoration does not occur, the cardiac arrest occurs. And ultimately, resulting death if respiration attempt are unsuccessful or well initiated. So no feature will come.
No feature will come. I agree.
Do not find any feature. The doctor will not find any feature during the PM examination. Abnormality not there. My friend is basing that lungs. Right lungs is placing much importance the right lungs in that feature will not come in case of cardiovascular collapse. And that doctor has explained how that picture, if you also find, kindly see the P 5 and 19. They have explained how the dried blood and dried urine has come on nostril. That has been explained page 109 of the paper book.
That is inherently defective.
Please, sir, please. When a counsel is arguing, please wait. Your turn will come. Page 109, that has been explained. I do not find presence of the blood, bad blood mixed with fluid in the inquest report, but it is found in the inquest report that coming of blood fluid from the nostril and mouth saying the dead body is turned. After some hours of death, blood and other fluids come out from the dead body through the different outlets, including nose and mouth. The dried blood, mucus and fluid, which was noticed during postmortem, that may be blood, mix and fluid that might be coming out at the time of inquest. During postmortem, we found that left ventricle empty, as blood of left ventricle might have come out from the body from mouth and nostril along with other fluid. Additional principle of natural medicine is the authority on the subject throughout the world. Books by Parrott and Modi are prescribed textbook for medical students. So they have P 5 and P 19, they have explained how the blood fluid comes from nostril and mouth. Not that it is not there. After turning the dead body, where from the outlet it has come. They have not suppressed anything to disbelieve the evidence of P 5 and 19.
Where is the inquest report, Mr. Kotke? The inquest report?
Inquest report. That must be there along with the. That is the exhibit one, my lord. That is the exhibit one. I have that report also to your lordship.
Interestingly, PW1 is the inquest witness, but he has spoken about the inquest in chief. In cross-examination, a lot of things are asked to him. He has gone to the house, he visited the place, found the relationship. Those are all has to be discarded, in fact. And the motive behind all these things is evident from the evidence of witness number 13. That is Sadhan Jaiswal, is a local person. PW 13, my lord. Can we have it for half an hour tomorrow? It's now 5 o'clock. We don't want to detain your lordship. Half an hour tomorrow?
Yes, I'll.
Yes, sir. Yes. Yes. Yes.
4 o'clock.
Before we join the responsibility
Yeah,